ಆಚಾ ಹಿಂಗೆ ಬರ್ದು ಕೋರ್ಟಲ್ಲಿ ಇದು ಒಂದು ಬರ್ದು ಇದು வாழ்ந்து ಬರ್ದು ಹಿಂಗೆ ಒಂದು ಇದು ಓಣುನಾಕ ಹಿಂಗೆ ಮೈಕ್ರೋಫೋನ್ ಕೊಟ್ಕೊ
மைக்ரோஃபோன் வேணாம் எனக்கு டைரக்டா கோட்டா
கேட்குறத பார்த்துக்கோ இல்லைன்னா இங்கே
கொஞ்சம் பக்கத்து போட்டு ಸಬ್ಮಿಷನ್ ಬೇಡ.
ಹಲೋ ಸರ್, ಶ್ರೀಶೈಲ ಸರ್.
ಹೇಳಿದ
ಇದು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇರುತ್ತೆ ಸರ್. ಎನಿ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಕಾಸ್ ಇಟ್ ವಿಲ್ ಗೋ ಟು ದಿ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಹೊಟ್ಟೋಗ್ಬಿಡುತ್ತೆ. ನಿಮ್ಮ ಆಫೀಸಿಂದ ನಿನ್ನೆಯಿಂದ ತುಂಬಾ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಗ್ತಾ ಇದೆ.
ನನ್ಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ, ನನ್ಗೆ ಇನ್ನೂ ಅದು ಅಡ್ಜಸ್ಟೇ ಆಗಿಲ್ಲ ಈ ಸಿಸ್ಟಮ್ ಹೊಸದು.
ಅದೇನೆ ಗೊತ್ತಾಯ್ತು. ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗು ನಿಮ್ದಲ್ಲಿ ಏನೇನ್ ಇರುತ್ತೆ ಎಲ್ಲ ವೆಬೋಸ್ಟ್ ಆಗುತ್ತೆ ಓಪನ್ ಇದಕ್ಕೆ.
ಅಯ್ಯೋ ತುಂಬಾ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ ನಿನ್ನೆಯಿಂದ. ಅದು ಇನ್ನೂ ಒಂದೆರಡು ದಿನ ಬೇಕು ನಮ್ಗೆ ಅಡ್ಜಸ್ಟ್ ಆಗುತ್ತೆ.
ಆಮೇಲೆ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಜಾಸ್ತಿ ಇದೆ ಸರ್. ಅದಕ್ಕೆ ಮೇಡಮ್ ಹೇಳಿದಾರೆ ನೀವು ಒಂಚೂರು ನೀವು ಕೇಸ್ ಕನೆಕ್ಟ್ ಆಗೋವರೆಗೂ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ. ನಿಮ್ ಕೇಸ್ ಇದ್ದಾಗ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಆಯ್ತು ಆಯ್ತು ಆಯ್ತು.
ಓಕೆ ಸರ್.
ಮ್ಯೂಟ್ பண்ணிடு. ಅದು ಮ್ಯೂಟ್ பண்ணிடு.
Malaj, one submission,
Yes.
Malaj. Malaj, this is the insurance account, Malaj. Liability is questioned. Short point for consideration.
Year. Year. Which year?
2019, Malaj. Covered, Malaj. Covered by your launch.
We'll see Tuesday. Yes. Take it. Let's sit on Wednesday. Yes.
Page-wise adjournments. This one, page number 5, serial number 16, 17. Page number 6, serial number 18 to 20. List number
Manoj, serial number 19, Manoj. Manoj, senior wanted to personally argue the matter, Manoj. He's unwell today. Any other day next week, Manoj, kindly.
This is matter on 22nd at the request of learned counsel, the appellant. No further
Okay.
adjournments. Inform the
Okay.
other side.
I will, Manoj.
Yes. Next.
list number 2, serial number, page number 8, serial number 18 to 23.
Yes.
This one,
With kind permission, Millet. Kind permission, Millet. Appellate counsel brother is admitted in the hospital. Heart operation is going on
Which case?
today. List number 3, 31 Millet. 31.1 is appearing on the 38 Millet
31.
and 38 Millet. Giri Mallaya.
KK Vasant.
KK Vasant is
KK Vasant.
present Millet. Is present Millet.
Yes, I am. In one case, I am the appellant and the other case is the respondent.
31. You are for the respondent.
31.1.
31.1. Then counsel appearing with the respondent. It is Ms. K. Vasant.
KK Vasant is
Yeah, Amma.
So you are
Giri Mallaya. I represent Giri Mallaya.
at the request of learned counsel appearing with the appellant in MFA 5946 of 2019. Any of these matters won't be heard. Don't worry. It will be a date will be given. No. Even if you're not there, date will be given.
But time time.
Not 17. It will go to July
Please.
2019 matters. We'll see when it reaches.
List number
Court
1,
will hear only till 16 or 17, 18, 19 will go. A longer date will be given. Yes.
Anxiety is there. Melody is.
Tell him that it is adjourned. No anxiety.
Please,
Yes.
please.
serial
Only to
number,
give the dates, to adjust the dates, I'm saying when it
Please.
reaches, we'll see. Yes.
Please, please.
serial number 1, Narendra Gowda, for appellant, Satish Kumar.
I appear for the respondent, my lord.
Yes.
My lord, this is a forward
Yes.
matter, my lord. Learner license holder,
Huh?
though the vehicle without a duly licensed pillion, so insurance company is not held liable. This is the
What
only
is the
point
law?
that is.
What is the
My
law
lord,
on that?
That is the Honorable Supreme Court, my lord, in Mandara Madhav Thambi case.
Yes.
That is 1995 Supreme Court, my lord.
Yes.
Page, sir.
That a duly licensed person must be there in the pillion. So pay and recovery, ultimately it boils down to pay and recovery. My insurance company has to pay to the claimant and recover.
Sir, page number 1995 Supreme Court, page.
But at page 1237,
1237.
What happened
Yes,
to his
madam.
video? What happened to his video? That is Shastri Shripad. Come to the finding of the court. Where is it?
well, this is reported in LAWS Laws FE 1995 1237.
The finding with regard to liability, which para?
That is para 14, my lord.
Yes. Please read para 14.
As I have indicated above, within a few days immediately after the accident given a regular license. There is no evidence of his disqualification, my lord. That is the previous para. That is para 13. Para 13, my lord.
Para 13
Undoubtedly,
says, para
para
13 says as per exhibit P7. It starts like that.
here, my lord, undoubtedly, Mr. Trivedi relied on the words of this part so as to contend that such a person must be a holder of a permanent driving license other than a learner license. But as we have seen, the category of license does not admit the holder of a permanent driving license, and the statutes like the provisions 96(2)(b phrase duly licensed indicates includes even a holder of a learner license. This intention is later clause
I
of the
think you're
policy.
looking at some other file.
It,
You are arguing some other case. Is it MBC number 3336?
My lord, this is 3336.
3336 is paragraph number 15.
designation at area.
Yes, my lord. Paragraph number 15. Yes, I'm sorry. Paragraph number 15, my lord. RW1, my lord, it starts like that. RW1 Sri S.R. Murali, senior assistant of the first respondent insurance company, has deposed in his affidavit that they have issued a policy pertaining to Hero Honda motorcycle bearing number KA40H59992 in the name of the second respondent for the period from 10/1/2009 to 19/1/2010. He further deposed that as on the date of the accident, that is on 26/3/2009, the rider of the said motorcycle, Santosh Kumar, he was in charge sheeted by the police, does not have driving license to drive said class of vehicle as on the date of accident. He has further deposed that the insured rider of the said vehicle has obtained learner license in its learner license 1425 or 0809. Same was valid from 17/1/2008 to 16/4/2009. Shows that the accused driver alone was driving the driving license vehicle, which is violative of that is on 26/3/2010. Hence, the accused was not authorized to ride the vehicle and not obtained DL to drive the said vehicle in a public place.
Yes,
He has
yes,
further-
I've seen that. Then coming to the, what
16
about the compensation?
Yes. 16 also, police inspector has said the investigation report says that no pillion rider was traveled in the offending vehicle. That is PW2, investigating officer. Then, my lord, the tribunal held the insurance company is not held liable because of that. The owner has to pay. At the end of that para, the tribunal has said, in view of all those decisions are aptly applicable to the facts of the case. Hence, the insurance company is not liable. The compensation 17,172 with interest at 8% per annum from the date of petition till payment is to be paid by the owner of the vehicle. Now that the Supreme Court has said learner license is also equivalent to right of the license, it doesn't say that he had no license. So violation of the license clause, the insurance company may be made to pay the amount and recover from the owner. To that extent, my lord,
Yes, please. Agreed with the orders passed in number uh, 3336 of 2009, dated 27 November 2012. The claimant is before this court seeking enhancement as well as questioning the liability fastened on the owner of the vehicle. The case of the claimant is that on 26/3/2009, at about 9:25 a.m., he was riding the motorcycle from GVK Gate, Bangalore, from so Narayanpura, Bangalore, on the left side of the road. At the time, the rider of the motorcycle came from the service road with high speed in a rash and negligent manner and dashed against his vehicle. As a result, he fell down and sustained a fracture of right temporal bone and head injury. He is admitted in the hospital and taken treatment. He has filed the claim petition seeking compensation of an amount of rupees 20 lakhs for the injuries sustained by him. When it comes to the liability, the tribunal has held that as on the date of the accident, the rider of the motorcycle who is charge sheeted with the police is not having a driving license to drive the said class of vehicle as on the date of the accident. And as per the evidence of RW1, the claimant, the RW1, the rider of the opposite vehicle has obtained the learner's license, and its learner's license, which is valid from 17/1/2008 to 16/4/2009, which shows that the accused, that is the driver, alone was riding the vehicle, which is in violation of the uh, it's a violation of the terms and conditions of the policy. As such, the court had held that the insurance company is not liable to pay the compensation and fasten the liability on the owner of the vehicle. Coming to the compensation, the court had granted compensation of 37,172 as per the table given below, para number 14. Strike. Land Council, though the matter was listed on 2/4/2025, there was no representation. This court, having heard the counsel for the respondent, posted the matter as part heard. Even today also, there is no representation. This is an appeal. It's an MBC of 2009, appeal of 2013, and spacing on the material on record. This court is inclined to proceed on the merits of the matter, basing on the available record. Land counsel appearing for the respondent insurance company submits that as on the without any, the assistance on a learner's license, the driver of the offending vehicle was driving the vehicle, and as it is like in violation of the terms and conditions of the policy, as such the tribunal has rightly held that insurance company is not liable to pay the compensation. When it comes to the compensation, it is submitted that the compensation that is awarded with the tribunal is just and reasonable. Next para. Having got the land counsel, the respondent insurance company, there was a material on record. The claimant had sustained a fracture injury and also a head injury. Under the head of pain and suffering, this court is granting an amount of rupees 40,000 towards the nourishment, attendant and transport for 3 days of hospitalization. Court had granted 3,000 and no interference is called for. And for the medical expenses also, the court had rightly granted 19,172. The court had not granted any amount on the head of loss of income during the later period. This accident had taken place in the year 2009, hence taking the notional income at 5,000. This court is granting an amount of rupees 10,000. In the light of the law later, and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 82,172, which has to be paid by the insurance company, and the same shall be recovered from the owner of the vehicle. Accordingly, the appeal is partly allowed. This pay and recover should come in the operative portion of the order also. Points 1, 2, 3. Yes.
Serial number 2, consider R for appellant. We can Arenda Babu.
For appellant, my lords.
My lord, I appear for the respondent.
Second.
I for third respondent.
Third, claimant appeal. Case of death, seeking enhancement and also questioning liability.
First liability on what?
Please. Lord, the involvement of two vehicles, my lords. Two luggage autos. The deceased was traveling in luggage auto bearing number K51, K37, 9488.
Who insured the luggage auto?
I am the insurer of the auto.
Two
in
luggage
which he
autos,
was-
my lord.
Huh?
The auto in which the claimant was proceeding,
Luggage auto, that's a
Luggage
luggage
auto.
auto. You have
Ah.
insured.
I have insured.
And the other auto is?
Shishela,
Yes,
No,
National
I
Insurance.
That is
National
a,
Insurance.
Both are insured.
no,
Yes.
insured. This is a luggage auto. Other one is?
That
one
is
is
also
al-
auto.
That is also luggage auto.
Luggage auto.
I'm appearing for third respondent, luggage auto. That auto is no way connected to this accident, in fact,
No, that luggage auto, you are the owner of the vehicle.
owner of the
Yes.
vehicle.
He is the insurer. He appeared for the insurance
Fourth
company.
respondent is.
Fourth
division
respondent
one.
is the insurer. He is the third respondent owner.
Yes.
Fourth,
Please come to the facts.
Please.
Let's see the facts. Read the facts.
First, I read from paragraph 15, page number 14.
Para number?
15, 15.
18.
Here in this case, there is no serious dispute with regard to the traveling of Annappa in the auto rickshaw bearing number KA379488. But there is a serious dispute with regard to involvement of other auto rickshaw. The evidence of PW1 is against to the petition averments and also exhibit P1. In exhibit P1, it is stated that when the deceased tried to spit the gutka, the opposite luggage auto came and dashed against his head. But in the evidence of PW1, has stated that the respondent has dashed against another luggage auto in which Annappa was traveling, and due to that accident was occurred, and in that accident he had sustained injuries and succumbed to the injuries later. But during the course of cross-examination, she has admitted that when Kallesh was driving the said auto rickshaw, she has admitted that Annappa and others were going to coolie work in the auto rickshaw, but in the ingenious method, a case has been registered against the one Vijayappa, son of Hanmantappa, stated that he was the driver of the auto rickshaw bearing number 379488. The said registration of the case against him is contrary to the actual fact and also the evidence of PW1. For the reasons best known to PW2, he has denied the suggestion that when Kallesh was driving the auto rickshaw, he has admitted exhibit R1 and also stated that for the first time before the tribunal, I stated there was a collision between the two vehicles. RW3 has given the evidence as per his defense, and nothing worthwhile has been elicited in his cross-examination to establish that his vehicle was also involved in the case. He has given complaint before the Superintendent of Police Chittorgarh as per exhibit R3 and R4. Of course, he has submitted submitted about the charge sheet filed by the police against him also, but he has examined two important witnesses to substantiate his contention. RW4 and 5, one Madamma and Lakshmamma, aged about 65 and 30 years. Respectively, has clearly deposed before the tribunal that they were traveling in Tyagaraja's auto rickshaw, and when they saw that one person has sustained injuries, Tyagaraja stopped his vehicle and given help to take the injured to the hospital. But subsequently, the police, in collision with the petitioners and other persons, have registered a false case against the respondent number 3. They are rustic villagers, have no worldly knowledge, but they have consistently deposed with regard to the actualities. Nothing worthwhile was being elicited in their cross-examination that they have deposed falsely. Their names appeared in the charge sheet as witnesses. Therefore, there is no reason to discredit the evidence of these two witnesses. It is pertinent to note that, as rightly argued by so and so, the learned counsel for respondent 3 and 4, the petitioner and other persons have changed the name of driver of the offending vehicle in order to get compensation. Also, overcome from the lacuna with regard to the DL. That itself clearly would show that they have also falsely implicated the respondent just to claim compensation. There is a clear evidence to show that disabled himself was responsible for his death when he tried to spit gutka. It appears he fell down from the luggage auto while trying to spit gutka and sustained injuries, and thereafter
The liability is fastened on whom?
owner, first respondent.
Why?
No reason, Maharaj. Plus, kindly see next para, page number 11.
No, involvement of the other vehicle is not there, that we can understand. Then why the responsibility, why the
Because it's a-
liability is not fastened?
It's a
on-
luggage auto. He was a gratuitous unauthorized passenger. So no liability is cast upon me.
But, they were, as owner of the goods, they're traveling in it.
No, no, he was not the owner. That's what, nowhere they say it is the owner of the goods. Their story is all, I mean, there is also not that they were owner of, traveling along with the owners. He's a bachelor. They were all unauthorized passengers.
Let us see what is that case? Come to the facts.
Yes.
As traveler,
As traveler, not Malad, she is going on coolie.
no, as coolie also.
Traveler,
How
but
can-
not the paid passenger, Malad.
Yeah, even then.
Yes,
No,
as
but-
per rule 100, the one person can be permitted to travel.
One person, the relation should be if it is if it's a goods vehicle as a owner of the goods or the employee of the company.
No, 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 Malad. May I read rule 100, Malad, for a moment. Subject to the provisions of this rule, no person shall be carried in a goods vehicle, provided that the owner or hirer are a bona fide employee of the owner or the hirer of the vehicle carried free or charges or a police officer.
You fall under which category?
Plus, I am the bona fide, I'm sorry, I am the bona fide employee of the
What is
owner. And plus, my submission is, Malad, here, the accident between the two vehicles. This is a case of composite negligence.
Will not go into that.
Please.
First of all,
Ah.
what is this? How are you traveling in this?
I am,
We'll first clarify
Please,
this
please.
aspect. No, you either as per under 100, which you're reading, you will not fall under any of those. Because you are saying that you are a traveler.
hirer, or the hirer of the vehicle carried free of charges. Without paying any charges, I am carried in the vehicle.
That's not allowed. That's not.
That is,
Yes, then
for a
now-
moment, once again I will read, Malad. But provided that the owner or the hirer are a bona fide employee of the owner or the hirer of the vehicle carried free of charges.
Hirer of the vehicle means what?
Carried free of charges, Malad. Yes, what is the complaint says, Malad? I will explain. What is the complaint says, Malad?
No.
Uh.
First to explain this.
Please.
Hirer of the vehicle, what is hirer of the vehicle means?
Yes, I'm just got into the vehicle because I know him, I know the driver.
That means hirer of the vehicle.
Well, it's free of charges, Malad. I am not the.
So you can't read
I was,
it,
if
if it is hirer, it's a,
Please.
there is no comma full stop in between. You can't split the sentence like that and read it. You cannot come under that. Next, what about the composite, about the opposite vehicle? Yes,
Lordship, kindly see the complaint.
yes.
The tribunal, Malad,
Motor vehicle rules.
complaint. Okay, FIR.
Please read your contents of your petition. Because you are bound by your pleadings.
Plus, the mother was examined as a PW1, Malad.
No, I said contents of your pleadings.
Pleadings.
With regard to that claim petition.
On 4/10/2011 at about 2:45 p.m., their son Annappa was traveling in the luggage auto bearing number so and so from Valakira towards Kunderi Kaval as a traveler. While the driver was driving the said vehicle near Vasnagara, the deceased tried to spit gutka. At that point of time, the driver of another luggage auto bearing number so and so came from opposite direction and dashed both vehicle each other. As impact of the accident, he sustained grievous injury and died while taken to the government hospital. The involvement of two vehicles, Malad. He was carried in the other vehicle. The offending vehicle came opposite direction and dashed against the deceased and also the vehicle, Malad. This is the case. Let's kindly see the complaint. The tribunal, Malad, on the ground that fixed the liability on the owner because there is implication of the driver and Malad without any violation of policy conditions.
No. As far as the auto in which you are traveling, you are a gratuitous passenger. You are not entitled. Insurance company is not liable. Owner is liable. There is no dispute on that. Then the burden lies on you to prove that the other vehicle is also involved in the accident. And it is a composite negligence. For that, there is a discussion. Please come to paragraph number 16 and 17 will answer that.
Yes.
Again, read that. Paragraph number 16.
PW3 has given evidence as per his defense and nothing worthwhile has been elicited in cross-examination to establish that His vehicle was also involved in this case. He has given a complaint before the Superintendent of Police, Chitradurga, as per Exhibit R3 and R4. Of course, he has submitted about the charge sheet filed by the police against him also. But he has examined two important witnesses to substantiate his contention, RW4 and RW5. One Madamma and Lakshmamma, aged about 65 years and 30 years, respectively, have clearly deposed before the tribunal that they were traveling in Tyagaraja's auto rickshaw, and when they saw that one person had sustained injuries, Tyagaraja stopped his vehicle and given help to take the injured to the hospital. But subsequently, the police, in collusion with the petitioners and other persons, have registered a false case against the respondent number 3. They are rustic villagers, have no worldly knowledge, but they have consistently deposed with regard to the actualities. Nothing worthwhile was being elicited in their cross-examination that they have deposed falsely. Their names appeared in the charge sheet as witnesses. Therefore, there is no reason to discard the evidence of these two witnesses. It is pertinent to note that, as rightly argued so-and-so, the learned counsel for respondent number 3 and 4, the petitioner and other persons have changed the name of driver of the offending vehicle in order to get the compensation and also overcome from the lacuna with regard to the DL. That itself clearly would show that they have also falsely implicated the third respondent just to claim the compensation. There is a clear evidence to show that the deceased himself was responsible for his death when he tried to spit gutka. It appears that he fell down from luggage auto while trying to spit gutka and sustained injuries, and thereafter died. But since it was a luggage auto, one Kalesh was not holding any license, and therefore they must have thought fit to create a story to implicate one Vijayappa and the Tyagaraja as accused number 2 and 1 respectively. Therefore, the evidence of PW1 and 2 is against the documentary evidence, and on the other hand, the evidence of RW4, 2, 4 and 5 is very clear, and there is no exaggeration, and therefore their evidence is to be accepted. Considering all these important aspects, I hold that the evidence of the vehicle of respondent number 3 is not at all involved in the accident, and therefore the claim of the petition against respondent number 3 cannot be accepted. Therefore, I am not inclined to accept the arguments of so-and-so, the learned counsel for petition in that regard. Hence, I hold that deceased has died while traveling in luggage auto, and therefore driver and owner of that vehicle alone are responsible for this death. Hence, I answer issue.
Yes.
Plus complaint to last mechanism.
Case of misrepresentation.
It must be in Kannada. It must be read it. It will be.
Date of accident 4/10/2011 at about 11:30 minutes, 2:30. The complaint is lodged very same on 4/10/2011 at 6:30. Complaint is given by the one of the occupants of that luggage auto.
They have not sustained injuries.
He not sustained injuries. ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ದಿನಾಂಕ 4/10/2011 ಬೆಳಗ್ಗೆ ಹೊಳಲ್ಕೆರೆಗೆ ನಾನು ಕೆಲಸದ ನಿಮಿತ್ತ ಬಂದಿದ್ದು, ಕೆಲಸ ಮುಗಿಸಿಕೊಂಡು ವಾಪಸ್ಸು ಊರಿಗೆ ಹೋಗಲು ಮಧ್ಯಾಹ್ನ 2:30 ಗಂಟೆಗೆ ಹೊಳಲ್ಕೆರೆ ಬಸ್ ಸ್ಟಾಂಡ್ ಹತ್ತಿರ ನಿಂತುಕೊಂಡಿದ್ದಾಗ ನಮ್ಮ ಗ್ರಾಮದ ಕಲ್ಲೇಶ್ ರವರ ಲಗೇಜ್ ಆಟೋವನ್ನು ವಿಜಯಪ್ಪ ಚಲಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದನು. ನಾನು ನಿಲ್ಲಿಸಿ ಹತ್ತಿಕೊಂಡೆನು. ಅದರಲ್ಲಿ ಕಲ್ಲೇಶ್ ಅವರು ಸಂಬಂಧಿ ಅಣ್ಣಪ್ಪ ತಂದೆ ಶಂಕರಪ್ಪ ಅವನು ಇದ್ದನು. ಆಟೋ ಮುಂದೆ ಚಲಿಸಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಗ್ರಾಮದ ವಾಸಿ ಶಣುಕಪ್ಪ ತಂದೆ ಟಿ ತಿಮ್ಮಯ್ಯ ಬೋವಿ ಜನಾಂಗ ಇವರು ಓಡಿ ಬಂದು ಆಟೋ ಹತ್ತಿಕೊಂಡರು. ಲಗೇಜ್ ಆಟೋ ಚಾಲಕ ವಿಜಯಪ್ಪ ಗುಂಡೇರಿ ಕಾವಲಿಗೆ ಹೋಗಲು ಹೊಸನಗರ ಮಾರ್ಗವಾಗಿ ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 2:45 ಗಂಟೆ ಹೊಸನಗರ ದಾಟಿ ಗುಂಡೇರಿ ಕಡೆಗೆ ಹೋಗುತ್ತಿದ್ದಾಗ ಅಣ್ಣಪ್ಪ ಎಲೆ ಅಡಿಕೆ ಹಾಕಿಕೊಂಡಿದ್ದವನು ಉಗಿಯಲು ತಲೆ ಹೊರಗೆ ಹಾಕಿ ಉಗಿಯುತ್ತಿದ್ದಾಗ ಎದುರು ಕಡೆಯಿಂದ ಒಬ್ಬ ಲಗೇಜ್ ಆಟೋ ಚಾಲಕ ತನ್ನ ಬಾಪ್ತು ಲಗೇಜ್ ಆಟೋವನ್ನು ಅತಿ ಜೋರಾಗಿ ಅಜಾಗರೂಕತೆಯಿಂದ ಚಾಲಿಸಿಕೊಂಡು ಬಂದವನೇ ಅಣ್ಣಪ್ಪನ ತಲೆಗೆ ಡಿಕ್ಕಿ ಹೊಡಿಸಿ ನಿಲ್ಲಿಸದೆ ಜೋರಾಗಿ ಹೊರಟು ಹೋದನು. ನಾನು ಕೂಡಲೇ ನೋಡಲಾಗಿ ಹಳದಿ ಬಣ್ಣದ ಲಗೇಜ್ ಆಟೋ ಇದ್ದು ಅದರ ಚಾಲಕ ತ್ಯಾಗರಾಜ್ ಇಡೇಳಿ ಗ್ರಾಮದ ವಾಸಿ, ನನಗೆ ಪರಿಚಯ ವ್ಯಕ್ತಿ ಆಗಿದ್ದು ಲಗೇಜ್ ಆಟೋ ನಂಬರ್ ಗೊತ್ತಾಗಲಿಲ್ಲ. ಅಣ್ಣಪ್ಪನಿಗೆ ನೋಡಲಾಗಿ ತಲೆಗೆ ಹಣೆಗೆ ಏಟು ಬಿದ್ದು ರಕ್ತ ಗಾಯವಾಗಿದ್ದು ಪ್ರಜ್ಞೆ ತಪ್ಪಿದ್ದು, ನಾವು ಹೋಗುತ್ತಿದ್ದ ಲಗೇಜ್ ಆಟೋದಲ್ಲಿಯೇ ಅಣ್ಣಪ್ಪನಿಗೆ ಚಿಕಿತ್ಸೆಗೆ ಹೊಳಲ್ಕೆರೆ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ವೈದ್ಯರಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಕೊಡಿಸಿ ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆಗೆ ಆಂಬ್ಯುಲೆನ್ಸ್ ನಲ್ಲಿ ಚಿತ್ರದುರ್ಗ ವೈದ್ಯರು ಕಳುಹಿಸಿಕೊಟ್ಟರು. ದಾರಿಯಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದಾಗ ಚಿತ್ರಹಳ್ಳಿ ಹತ್ತಿರ ಮಧ್ಯಾಹ್ನ 3:15 ಗಂಟೆಗೆ ಅಣ್ಣಪ್ಪ ಮೃತಪಟ್ಟಿರುತ್ತಾನೆ. ಆದ್ದರಿಂದ ಅಪಘಾತ ಮಾಡಿದ ಲಗೇಜ್ ಆಟೋ ಚಾಲಕ ತ್ಯಾಗರಾಜ್ ಇಡಹಳ್ಳಿ ಗ್ರಾಮ ಇವನ ವಿರುದ್ಧ ಕಾನೂನು ರೀತಿ ಕ್ರಮ ಜರುಗಿಸಲು ಬೇಡುತ್ತೇನೆ.
Yes, what is it? Please
Plus, this
translate
complaint, gist of the complaint is that, my lord,
it.
one Vijayappa is the accused number 2. He was, my lord, driver of the luggage auto bearing number KA 379488, my lords. And the offending vehicle, my lord, another auto, that is auto bearing number K 511092, was driven by Tyagaraj. Plus, he given complaint at 6:30 AM. Incident was occurred on 2:30 PM, and complaint was given on 6:30 PM. Within 2 hours, alleging that, my lord, the Vijayappa was, this one Tyagaraj was coming in the another auto from the opposite direction.
They didn't say about this driver. They said some other name.
That is the judgment is wrongly. The judgment is says we have implicated the Vijayappa to show that Kallesh is not having the driver. No complaint is lodged against the Kallesh. Kallesh is the owner of the is the first auto rickshaw wherein the deceased was traveling. In that vehicle was driven by Vijayappa.
Whom you have examined in support of your case?
Plus PW2, Malaj, is the eyewitness and also traveling in the said vehicle because he given evidence as per the charge sheet. Plus he given the complaint that, Malaj, while spitting gutka, the other vehicle dashed against to him and he sustained the injuries and died during the course on the way to the hospital. But the charge sheet is filed by the investigation officer after completing the charge sheet. The charge sheet says that the offending vehicle opposite direction came and dashed against the deceased and also the vehicle. There is involvement of 2 vehicles. That on that line only, my lord, PW 1 and 2 given the evidence. But tribunal wants that, my lord, the evidence given by the petitioners is against to the complaint versions because I have to follow the version of the charge sheet. As per the charge sheet version, I given the evidence. Let's see the charge sheet. Charge sheet is says that, my lord,
So you were sitting in the auto. How the other vehicle will come and hit you?
plus when as per the complaint arguments that, Malaj, when he tried to spit, the other vehicle dashed against the deceased.
You will still be in the auto.
In the auto, Malaj. I am not outside the auto.
Hmm.
Other vehicle hit the deceased. Plus
Where
he
is
is a
that,
purely third party, Malaj.
The postmortem certificate. Let's
Please. Exhibit P4, Malaj, PM report.
Yes.
I am of the opinion that the cause of death is to shock as a result of cerebral injuries, head injuries.
He died at the spot.
He died on the way to the hospital. Initially, he was taken to Vadalkar Hospital.
Now read the evidence of PW2.
Two, please. ನನಗೆ ಸದರಿ ಕೇಸಿನ ಸಂಗತಿಗಳು ತಿಳಿದಿರುತ್ತವೆ. ಸದರಿ ಕೇಸಿನ
Right,
ಅರ್ಜಿದಾರರ ಪರಿಚಯ ಇರುತ್ತದೆ ಮತ್ತು ಮೃತ ಅಣ್ಣಪ್ಪ ಪರಿಚಯ
Read everything. What is relevant, you please read.
relevant, my lord. He says, KA 511092, that is the third respondent, came from opposite direction and dashed against the Annappa Mattu and the auto,
Auto.
the luggage auto, opposite vehicle. He dashed against both deceased and also the opposite
You
vehicle.
have the evidence, Mr. Lingaraj?
That's the evidence, yes, that
No,
is.
you have the.
Here is the evidence.
That is the evidence, because as per the charge sheet says only that, my lord, the involvement, there is a head-on collision between the two vehicles.
No further evidence. Anything could be elicited in the cross-examination by them.
Cross-examination, he says, my lord, they suggested that this question is not in the complaint.
What is elicited? They might have, what is the answer of the witness?
ಅಣ್ಣಪ್ಪನಿಗೆ ಬಿಟ್ಟು ಬೇರೆ ಯಾರಿಗೂ ಪೆಟ್ಟಾಗಿದ್ದಿಲ್ಲ ಅಂದ್ರೆ ಸರಿ, ಎಕ್ಸೆಪ್ಟ್ ಅಣ್ಣಪ್ಪ, the deceased, no other persons are sustained injuries in this said accident.
If that it comes and hits the auto driver and other inmates could also have sustained.
But is evidence, the complaint is that Malas, he tried to split Malas, the gudga, he put his head outside the auto, that the other auto came and hit the head Malas.
That means not the auto, only hit him.
It both Malas, for Malas, this is a small road, the vehicles are Malad while
If it hits his auto, something would happen to the inmates also, not alone this person.
others have not sustained injuries, Malas.
Even the driver
Admittedly,
has not
others have not sustained injuries.
What was the IMB report says?
No damages, because the vehicles were recovered after 10 to 15 days from the date of accident. No damages to both the vehicles. But admittedly, Malad, the other vehicle hit to the head of the deceased.
The P8.
Third party to the other vehicle. Because driver cannot, Malad, road his vehicle rash and negligently without taking care of the other road users, Malad.
Yes.
Charge sheet is, Malad, attained finality.
P7, what did you say?
Well, at P8, IMV report clearly says no damage caused to the vehicle. If it's a head-on collision between two vehicles, some damage must be there. No damage is caused to the vehicle. IMV report clearly says that clinches the whole issue. And no injury is caused to any of the other inmates. It is a head-on collision.
So it is not your case, you have read both insurance companies, owners of
Yes.
the vehicle as respondents. You are saying that it's a composite negligence.
Yes.
Then how it will go? How it is according to you, the other vehicle, no, the second story, the second line of your argument is the other vehicle has come and hit. Then in that case, why it would be the negligence on the part of the driver in which you are traveling?
Malas, because Malas, I am traveling in the said vehicle. That vehicle is also Malad involved in the said accident, Malas. It is the duty
Yes.
of the driver
The other
to
vehicle
take
has not
care,
involved in the accident. That is the case.
to care of the Malas travelers in the vehicle. Because Malas,
You
he also
say-
negligently rode this vehicle. That is the,
You yourself say you kept your head outside and you're splitting.
yes. Then that time it is the duty of the driver to control the passengers, Malas. The one judgment of this honorable court, Malad, is held that Malad, in a KSRTC bus, the one passenger put his
Yes,
hand
sir.
and other vehicle, Malad, Malad dashed against his hand. This honorable court held that Malad is the duty of the conductor and driver to take care of this their passengers.
Driver and conductor will control.
Yes, in that case,
people in the bus.
Malad. In this case, Malad, is the duty of the driver to look after the passengers carried in the vehicle, Malad.
How can it?
Hence, Malad, in the Kenny case, as is hold that Malad, the injured or deceased, legal can go against any one third person. And Malad, there is no sufficient evidence on record. The tribunal has to hold that Malad, the liability is jointly and several, Malad.
Composite
Here, Malad,
negligence.
involved charge sheet is filed against these two vehicles, Malad. Charge sheet attained finality. Nobody is questioned the charge sheet, Malad. And they are not disputed the charge sheet. Charge sheet is after conducting investigation, police have laid against charge sheet both the driver of both the vehicles, Malad.
Owner
Such
has not.
is a case, purely a case of composite negligence. My lord, even if it is, even I am also the third party to the opposite vehicle, my lord. I can go against any one trespasser, my lord. And in this case, my lord, I request this honorable court, it may be held as the jointly and severally, my lord.
Owner having suffered an award has not challenged the award. Kindly see, my lord.
Who?
Owner, liability is passed on the owner, he is not questioned the award.
He has not come up in appeal. He has not come up in appeal. No owner will keep quiet when liability is fastened on them, financial burden. If he is not at fault, why should he keep quiet? He has not come up in appeal.
Please come to the compensation part.
I wanted to help them and they have implicated. Vehicle not involved in the accident is the case. Case of misrepresentation.
Accident of the 2011, deceased is age about 20 years, my lord.
Age about?
20 years.
Uh,
Tribunal considered income of the deceased at rupees 4,500
2009
per
is the
month.
accident.
Issue number 2,
2009,
2011.
11.
4,500 is considered by the tribunal. And
According to
deducted,
the claimant, how much?
sorry,
How
my
much, how much the deceased was earning according to them?
10,000 per month. Deducted 50% and awarded 3,51,000 towards loss of dependency. Claimants are mother and sister, my lords.
What is the age of the sister?
47 years. Lalitamma 45 years and Shankarappa,
You must
mother and father, sorry, mother and father. $50,000 towards love and affection is awarded, 25,000 towards funeral expenses. Total 4,26,000 is awarded.
What is the multiplier? 18.
18.
18.
13. And mother is.
Please come. The claimant is before this court. Agreed with award passed in MVC number 292 of 2012, dated 23rd December 2013, both on the ground of questioning the
One more
liability that is
submission,
passed
my lord.
on.
The insurance company, lords, not, in their evidence not disputed the involvement of their vehicle, my lords. Their case is only that regarding DL and implication of the bill.
The both on the ground of liability fastened on the insurance company, on the owner of the vehicle as well. The as well seeking enhancement of the compensation. The facts of the case are on 4/10/2011 at about 2:45 p.m. The son of the claimant was traveling in a luggage auto from Holekere towards Kunderi Kaval as traveler. While the driver was driving the said vehicle, the deceased tried to split the gutka. At that point in time, the driver of another luggage auto bearing another auto came from the opposite direction and dashed both vehicles and both and there is a head-on collision between both the vehicles. As an impact of the same, he sustained grievous injuries and died while taken to the hospital. According to the claimants, he was earning an amount of rupees 10,000 per month and sought compensation of an amount of rupees 18 lakhs. The tribunal had granted compensation of an amount of rupees 4,26,000. When it comes to the liability, the court has held that the petitioner, the deceased was traveling as a gratuitous passenger in a goods auto, and the owner alone is liable to pay the compensation. When it comes to the liability of the involvement of the opposite vehicle, court had completely not accepted the contention and of the claimants and held that there is no involvement of the opposite vehicle. The second respondent had insured the luggage auto, Slingrush.
In which he was 3948.
That's what luggage auto is insured by General
Cholamandalam.
Cholamandalam.
Second respondent has insured the luggage auto in which the deceased was traveling. And the fourth respondent, National Insurance Company, had insured the opposite vehicle. It is important to look at the findings of the tribunal when it comes to the liability. The court observes that the RW3 has examined RW4 and 5, that is one Madamma and Lakshmamma, who are aged about 65 years and 30 years, have deposed before the tribunal that they were traveling in Tyagaraju's auto rickshaw, and when they saw that one person had sustained injuries, Tyagaraja stopped his vehicle and given up to take the injured to the hospital. But subsequently, the police, in collusion with the claimants and other persons, have registered a case against respondent number 3. The court also observes that the rustic villagers have no worldly knowledge, but they have consistently deposed with regard to what has happened. Nothing worth has been elicited in their cross-examination that they have deposed falsely. Their names also appeared in the charge sheet as witnesses. The court felt that there is no reason to discredit the evidence of the witnesses. The court also observed that the claimants have changed the name of the driver of the offending vehicle in order to get compensation and also to overcome the lacuna with regard to the DL. That itself would clearly show that they have also falsely implicated the third respondent just to claim compensation. There is clear evidence to show that the deceased himself is responsible for his death when he tried to split gutka. It appears that he has fell down from the luggage auto rickshaw while trying to split gutka and sustained injuries and thereafter died. But since it was a luggage auto, one Kalesh was not holding any license, and therefore there was a thought fit to create a story to implicate one Vijayappa and this Thagaraju as accused number 2 and 1 respectively. The court observes that the evidence of PW 1 and 2 is contrary to the documentary evidence, and the evidence of RW 2, 4 and 5 is very clear and there is no exaggeration and therefore that evidence is to be accepted. And basing on this, the court has come to the conclusion that the third respondent is not at all involved in the accident. And as the claimant was traveling in a luggage auto, the driver and the owner of the vehicle alone are responsible for his death and they are liable to pay the compensation. Next paragraph. Learned counsel appearing for the claimant submits that the court has failed to appreciate the oral and the documentary evidence placed before the court. It is submitted that he was traveling in the said auto and he falls under section rule 100 of the motor vehicle rules,
Karnataka Motor Vehicles.
Karnataka motor vehicle rules, and submits that the he cannot be considered as a gratuitous passenger and when he had sustained injuries and when both vehicles are involved, when there is a composite negligence, both the owner and insurer of both the vehicles are jointly and severally liable to pay the compensation. It is submitted that the court on assumptions and presumptions had held that the opposite vehicle is not involved in the accident when the charge sheet is filed against them. Then counsel submits that nobody has questioned the charge sheet, and and in that case, it's not open for them to say that the accident had not taken place. It is further the submitted that it is never the case of the insurance company that the vehicle is not involved in the accident. It is submitted that it's a case of composite negligence and both the owner and the insurance company are jointly and severally liable. When it comes to the compensation, it is submitted that when according to the claimant, the deceased was earning 10,000. Court had taken the salary at 4,500, which is not just and reasonable. Further, under the other heads also, the compensation that was awarded is not reasonable. Next para. Then counsel appearing for the second respondent insurance company, which had insured the luggage auto in which the deceased was traveling, submits that it is a goods vehicle and at best it could travel if he is a owner of the goods or the employer of the employer as is the employer of the employer as an employee can travel in the said goods vehicle, but it is submitted that that rule 100 will not cover the deceased, and when he is traveling in a goods vehicle he has to be considered as a gratuitous passenger, and in the light of the settled law, once he is a gratuitous passenger he is not entitled, the insurance company is not liable to pay the compensation. He submits that the tribunal has rightly held that the insurance company has rightly exonerated the insurance company and fastened the liability on the driver and owner of the vehicle. He submits that no interference is called for with the said order passed by the tribunal. Learned counsel appearing next parallel counsel appearing for the fourth respondent insurance company, which had insured the opposite vehicle, submits that court had rightly considered the evidence and rightly held that the offending vehicle, as stated by the claimants, was not involved in the accident, which is supported by the evidence of RW 4 and 5. RW 4 and 5. He submits that.
And also the written statement, my lord. Written statement of third respondent.
And also the written statement of the third respondent. It is submitted that
It is P8. IMV report says no.
it is submitted that according to the claimant, it is a head-on collision between both the vehicles. And once it's a head-on collision, there are other inmates in the auto. There is and inmates in the auto, and admittedly nobody had sustained injuries. As per the IMV report, there are no there is no damage to both the vehicles. There are no damages to both the vehicles. He submits that at one stretch, he says that the vehicle, it is a composite negligence. And on the other stage, it is stated that when he was spitting, when he put his head out to spit the gutka, at that time, the opposite vehicle and has come and hit.
Not to be vehicle.
It is submitted that the evidence is not consistent and the tribunal had rightly disbelieved the evidence of the claimants, that is the evidence of PW1 and the eyewitness PW2, and rightly held that the insurance company, that the offending vehicle is not involved in the accident. Next para. You are for the owner of the
Owner of the vehicle. the
Offending
car-
vehicle.
Offending opposite way.
opposite, the owner of the opposite, the counsel appearing for the owner of the opposite vehicle submits that his vehicle was not involved in the accident. And in fact, when they saw the accident and tried to help the deceased at that point of deceased, they have been implicated in the case, and their case is and in support of their case, they've examined RW4 and RW5, and their evidence is consistent with their pleadings, and nothing could be elicited from the witnesses, and court had rightly placed reliance on the evidence of the said witnesses and rightly held that the third respondent vehicle, the third respondent, the vehicle is not involved in the accident. Next paragraph. Having heard the learned counsels on either side, produce the material on record. Before proceeding with the matter, the close scrutiny of the pleadings of the claimant of the claim petition is essential in the facts and circumstances of the case. As per the claim petition, it is stated that on 4/10/2011 at about 2:45 p.m., while the deceased was traveling in a luggage auto vehicle as a traveler, when the said vehicle reached near Hos Nagara, Gunderi Road at Holkere Taluk, another luggage auto driven by its driver also came there. At that time, the deceased intending to split Kutka, then the drivers of both the said vehicles have driven their vehicles in a rash and negligent manner without observing the traffic rules and regulations and dashed with each other, and to this impact, deceased sustained grievous injuries all over his body. Immediately was shifted to the hospital, and as per the postmortem report is exhibit P4.
P4.
Huh?
P4.
Exhibit P4. Cerebral injuries.
Again, RW1 is started. As per exhibit P4, the postmortem report, the cause of death is that it's a shock as a result of cerebral
Injury.
According to the claimant, it is a composite negligence and both the vehicles are involved. If it's a head-on collision, there are persons traveling in the opposite vehicle as well as in the vehicle in which the deceased was traveling. Admittedly, none of them have sustained the injuries, and admittedly, as per the IMB report, there are no damages to both the autos, which clearly demonstrates that it is not a head-on collision. The At one stretch, he says that he has kept the claimant say that the deceased has kept his head out to spit the gutka, and there is negligence on the part of the driver in which he is traveling. Coming to the vehicle in which he is traveling, admittedly, he is traveling he is traveling in the said goods vehicle, and as submitted with the learned counsel, he cannot fall under Rule 100 of the Karnataka Motor Vehicle Rules. He is neither he is the employee nor he is nor he is owner of the goods. In that case, he cannot travel in a goods vehicle. In that case, he is a gratuitous passenger. As far as the respondent number 2 insurance company is concerned, the insurance company is not liable to compensation as is a gratuitous passenger. Coming to the negligence or the involvement of the vehicle is concerned, in the light of the evidence of RW 4 and 5 and the fact that there is no damage to the vehicle and there is no damage to the vehicles and no injuries to either to the PW2 or to RW4 and 5. Even the theory put forth by the claimants that it is a head-on collision is also this court is not able to accept the said contention. In the considered opinion of this court, the court had rightly held that the vehicle is not involved and vehicle is not involved. In view of the same, the liability that is fixed on the owner and driver of the vehicle in which the claimant is traveling holds good and no interference is called for. Next one. Coming to the compensation. According to the claimant, is earning an amount of rupees 10,000. Considering the fact that this accident has happened in the year 2011, this court is taking the notional income at 6,500. Considering his age of 20, future prospects at 40% comes to 2,300. Then his income is 9,100. As he is a bachelor, 50% has to be deducted towards his personal expenses. Then his contribution to the family would be 4,515 to 12 into 18 under the head of loss of dependency is entitled for an amount of rupees 9,82,800. As there are two claimants towards consortium, 44 into 2, 88,000. Funeral expenses 36,000. And in the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 11,16,800. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 4,26,000 to 11,16,800, which the first respondent owner and the driver.
Driver is not a party.
No,
driver is
first
not.
respondent alone is liable to pay the compensation.
But much.
Number 3, Vasudev Murthy BK for appellant. Nagesh S.
I think DS Sridhar, I am told that he has not appeared for IFCO Tokyo. He is not appearing so many. DS Sridhar is not appearing so many times. Whether he has filed wakalat or not.
Look at it, whether the wakalat is filed.
DS Sridhar ಇದೆಯಾ ನೋಡು. Huh?
Yes, Sridhar has filed wakalat.
Just file the wakalat. Anyhow, we'll hear. He's not
Yes,
coming.
yes, yes. 11 years old boy,
Hmm.
he has sustained injuries.
Hmm.
Dr. PW2 has assessed the permanent disability to an extent of 39%
To the limb or body?
to the limb and 19% to whole body.
Hmm.
The tribunal has awarded a sum of rupees 50,000 towards disability.
Let us see that table.
Table.
Hmm.
Here, in view of the law laid down by the apex court, in the case of Master Ayush, baby Kajal, and a recent decision, baby Sakshi, an amount of loss of dependence, loss of future earnings has to be granted. Taking the income, notional income at the time of the accident. Therefore, she is entitled for loss of future earnings. And this court also, in one of the cases, has held in respect of minors, they are entitled for compensation under the head of pecuniary damages and non-pecuniary damages.
Okay, Judge. Hmm. Yes. I'm looking at baby Sakshi.
Yes, baby Sakshi. Relying upon the judgments of Master Ayush and Kajal, in that case, 75% disability has been stated by the doctor.
So, no, a case where there is 75% disability or 90% disability, like in Kajal and Ayush case, and even in I mean, below 15 or 20,
Yes.
is it the same calculation to be made is the question.
Yes, ma'am. My submission is that judgments was also referred by the learned single judge of this court.
Hmm.
And relying upon those judgments, he has rendered a judgment.
Hmm.
Justice Sanjay Gowda, that's what I am giving the judgment.
Hmm.
Compensation has to be granted under two heads, pecuniary and non-pecuniary damages. He made a table in what manner it has to be granted.
Where are the insurance counsels?
Yes, Reader.
Yes, Mr. Lingaraj.
See the IFCO Tokyo.
No, not IFCO Tokyo. This judgment 27 September 2024. Have you seen?
I'm not sure.
This Sanjay Gowda's judgment.
Sanjay Gowda, I told it in detail.
Now, as per this, the future law, a table has been prepared. As per that, into the percentage of disability would be the pecuniary loss.
That's true, Madam. I'm told that there's a decision, but it is not gone in detail. But all depends upon the facts of the straight jacket formula cannot be formulated unless, subject to what is said in the judgment. Dear Sridhar, your lordship may kindly enlarge time. I will inform Mr. Sridhar.
I'm told he's not coming to the court. He's not
aware.
well.
Who are other advocates? What are this? Which is IFCO Tokyo.
Pradeep is there, Shivannaya Gowda is there,
Shivannaya Gowda is there.
Pradeep is there.
Is there
N.
today?
Krishnaswamy is there.
Huh?
N. Krishnaswamy, Pradeep.
Shivannaya Gowda is there for
Yeah,
IFCO Tokyo.
Shivannaya Gowda is there.
Please
ವಕಾಲತ್
inform.
ಹಾಕಿದೆಯಾ ನಮ್ಮದು ಶ್ರೀಧರ್ ವಕಾಲತ್ ಹಾಕಿದಾರ
ಹಾಕಿದ್ದಾರೆ. Shivannaya Gowda ಅವರು ಇದ್ದಾರೆ.
Ask him to come. Please inform Mr. Shivannaya Gowda. Ask him to come. Once he comes, I'll take up this one.
Yes, I will go to house matter because of health issues. I may be permitted to.
No, he's got some health issues. He is not unable to
Yes.
wait.
Yeah, yes.
Yes. Pasu. Next.
Cell number 4. Ravi S. Samprati for appellant.
Ravi says that this matter of ESI coverage is referred to a larger bench by Justice Pope.
That's what I
referred.
said
So
the other
we
day.
called after vacation.
4 and 4.1. There's this matter on July 21st.
Much.
Cell number 5. Cell number 5.
Appear for respondent Malad, in the first case Malad. Malad, the case of death Malad, in second matter I am for the appellant.
Mahendra Swami P. the respondent.
Who are the respondents?
I am for the respondent Malad. Sir.
You are for the respondent.
Yes Malad. In connected matter I am for the appellant.
No representation for the appellant insurance company.
It's not insurance company Malad. It's a
Cholamandala, whatever it is, no representation for the appellant. Give the proceeding sheet.
But the case of death Malad, this is the.
Oh, your appeal is there.
Yes Malad.
Yes, we'll consider your appeal. There is no representation on behalf of the insurance company. the matter, when the matter came up on 28/6/2024, again on 2/4/2025. As the matter is directed to be registered today under the caption dismissal, today also there is no representation. Accordingly, MFA number 7795 of 2015 is dismissed for non-prosecution. Yes.
The case of death, Malad, the accident in the year of
To the
2010,
file.
23/9/2010, Malad. The disease is 22 years.
Accident, date of accident.
23/9/2010, Malad.
You are for, you are on enhancement.
Yes, Malad.
23?
23/9/2010, Malad. The disease is aged about 22 years. The claimant is father and mother, Malad. The father is,
Some,
Malad, is earning a private company, Malad. 10,000 rupees earning, Malad.
according to him.
Yes, Malad.
How much was taken?
The trial court has considered only 4,000 4,000 rupees, Malad.
4,000.
Yes.
Then 5,500. The liability is on the insurance company.
Liability is fixed to the finance company.
That's what,
Yes,
on
Malad.
the
Yes,
respondent.
Malad. Father and mother, Malad, the 50% was deducted, Malad. He's unmarried. And he is
Is it unmarried? 50% has to be deducted.
50%.
So we will take 5,500. Is 40% future prospect.
And future prospect may be considered.
Parents of the dependents.
Parents, Malad. The father is no more, Malad. Now, after filing up the appeal, he died.
It comes to 9,65,600. How much was awarded?
Malad, 6 lakh 6,000.
6 lakhs?
6,000.
Please come. The agreed with the award passed in embassy number 571 of 2011, dated 14th July 2014. The claimant is before this court seeking enhancement of the compensation. It's a case of the claimant that the deceased was working as a
private fact
working
company.
in a private company and earning an amount of rupees 10,000 per month. The tribunal had taken the income at 4,000 and granted the compensation of an amount. Where is that calculation? Which
The
paragraph?
calculation in the para number 13 of the judgment, Malad. 3,250 into 12 into 14. The multiplier is
Had taken, the court had taken the age of the mother and multiplier 14 has been adopted and future prospects are not granted.
Not
and
granted.
future prospects and without granting the future prospects had granted the compensation as per the table given below. That is para number 17 extracted. The, from, on several occasions, there was no representation on behalf of the insurance land counsel appearing for the claimant submits that the court had not properly appreciated the evidence and the order passed by the court is contrary to law as well as contrary to the evidence on record, and the compensation needs to be enhanced. The next part, the respondents have preferred an appeal and the same is dismissed for non-prosecution. There is no representation on several occasions by the respondents before this court. Next para, having heard the counsels on either side, there is a material on record. In this case, the accident had taken place in the year 2010. Though there is no evidence on record with regard to the income, this court is inclined to consider the notional income at 5,500. As the age of the claimant is 22 years, as future prospects at 40% will come to 2,200, the income is 7,700. As is a bachelor, 50% has to be deducted towards personal expenses. Then his contribution to the family would be 3,850 into 12 into 18. The loss of dependency would come to 8,31,600. Consortium, where the mother and father of the claimants, 2 into 44, 88,000. Funeral expenses, 36,000. In the light of so and so, 10,000. Altogether, the claimant is entitled for an amount of rupees 9,65,600. Accordingly, the appeal is partly allowed, enhancing the compensation from 6,06,000 to 9,65,000. The enhanced amount shall carry 6% interest. Where? The claimant shall amend the cause title within one week from today.
Today itself I have amended, my lord.
You have amended?
And amendment appeal memo is also.
The petitioner had filed the amended cause title. Yes. Any delay? Look at it. If the delay is there, tell them. Yes, next.
Cell number 6.
My lord, I am for the appellant, my lord. I'll pay the PF within a week, my lord, for fifth respondent.
The PF shall be paid within a week, or else the appeal shall stand dismissed without further reference to the court. Yes.
Cell number
Next.
8. 7.
One submission, my lord. Either in the cross objection, my lord, the no notice was served on anybody.
Cross objection in MFA crop and counsel for the petitioner shall serve the copy on the counsel appearing for the respondent within a week.
Text notice.
Print the name of Mr. D. Vijay Kumar.
Cell
for
number
the
7.
respondent. Yes.
The insurer appeal on absolute negligence on the part of the injured plaintiff.
Contributory negligence.
I filed it.
Not contribute, absolutely on my humble submission, absolutely the part of the first respondent.
I filed application for withdrawal the deposited amount.
Ready for disposal. Ready disposal amount.
It's MFA of 2022. Delete from the caption dismissal. Admit list this matter for final hearing.
Ready. Then he is also ready.
List this matter in the month of July 15th. Yes, next.
Cell number 8. For orders matter. Cell number 8. Srinivas KN.
Yes, I am for the.
Non-filing of acknowledgement for having paid the cost of
May
rupees 1,000.
please your lordship. That appeal is by the insurance company. Madam. I'm seeking your indulgence to waive off the cost.
How you can ask it? You can ask it by filing an application. When an order is passed,
That
you
oral
can't make a
submission
submission.
can be considered by your
How
lordship.
can it be? When there is a judicial order,
Okay.
how can it be
Sorry,
modified?
madam. I will make application.
Yes. And this is a MFA of 2014.
14 years.
What is, let's see on what ground you are before this court.
Yes. Vehicle, my lord, is not involved. Vehicle involved is different and
Let us see
FIR
the
is different.
finding of the court on that aspect.
That page, para 11,
para
Yes.
11. This is the case of the petitioner that on 16/5/2005 at about 1:30 am, when Amruta, husband of the petitioner, was proceeding in a motorbike, so and so, from Kunigal to Bangalore, the Premier Padmini car bearing number CMM 5678 came from the backside and dashed against the motorbike. That is their case, Milad. This was, I further read, para 12, respondent number 1 is contended that the vehicle was insured with the second respondent and the policy was in force on the date of accident. The accident, the respondent number 2, while admitting the insurance policy in respect of Premier Padmini, so and so, restricted its liability to the terms and conditions of the policy. It's conducted both the drivers of the vehicle and not having valid driving license at the time of accident. The respondent to further contended that the petition is bad for non-gender of necessary parties. The respondent has not admitted the involvement of the vehicle in the accident. PW 1 and 2 depose in consensus with the petition governments. Para 13. In order to prove the accident, got marked exhibit so and so, so and so. The exhibit, third line, Miller. Exhibit P1, FIR discloses that Kunigal police registered crime against the driver of Tata Qualis. Whereas the complaint is against Padmini. Tata Qualis bearing number so and so, number K04887 for the offences punishable under section 279, 337 and 387 of the and IPC, read with 134 AB and 187 of MVC Act. Exhibit P2 charge sheet also discloses the against the driver of the Premier Padmini car bearing number CMM 5678 for punishable so and so. The respondent number 2 inter-alia taken defense that the vehicle is not involved in the accident, hence the second respondent is not liable to pay the indemnify the respondent number 1. About 3 lines from para 14. PW2 in his evidence has stated that on the said fateful day, 2 persons were proceeding in K02 E6690 motorbike. At that point of time, a Premier Padmini vehicle bearing number CMM 5678.
You can come to page number 8, bottom, about 6 lines.
Yes.
The respondent,
has not adduced any rebuttal evidence to substantiate the contention, and the respondent is solely relying on the discrepancy regarding the FIR, vehicle in the FIR. It is pertinent to note that the respondent has not specifically denied the involvement of vehicle in the written statement, even after the remand case with a direction to lead further evidence. The respondent has not adduced evidence to substantiate its questions in contention. The respondent has not examined the investigation officer to clarify the position. The petitioner has placed evidence regarding the discrepancy in the respect of FIR in the absence of specific denial regarding the involvement of the vehicle and rebuttal evidence. The contention of the respondent regarding non-involvement of the vehicle is not acceptable. The evidence of PW1 and 2 coupled with the exhibit so and so shows that the accident occurred on this said date due to the rash and negligent driving of the driver of the Premier Padmini bearing registration number CM 5678. The petitioners have proved the accident. That is the in the connected matter. It is in the similar matter. There are another matter, my lord, in MFA number 5113/2009, my lord. It is by holding, my lord, that accident finding it regarding the involvement of Tata Qualis is correct.
Where is the other case? There is no other case here. It's only a single matter.
Yes, my lord. In another one more matter, my lord, in the MFA number, there is an order wherein, my lord, it says in that Premier Padmini is not involved, only Qualis is involved. That is the finding of the order in MFA 5113/2009.
Where is that?
The copy of
So in
that.
this accident, how many are injured?
2, my lord.
In respect to the other injured, that was the finding in the
Yes,
by the
yes,
court.
yes, yes, my lord.
List along with so and so.
MFA 5113/2009.
It's already disposed.
Yes, yes, my lord.
Give that.
5113/2009.
You have the copy of it?
Yes, I got
Please
it
give that.
just present. Para. Yes. Page 3, page 3.
See, he has given him one. Before which court this is filed?
Sir, DDP.
This,
Before which court this is filed?
this is same before this on court, my lord.
Not this court, MFA that I can
MEC
understand.
number, MECT Zasan.
This is also.
No, it's all same. That is MEC 73. This is 74. Correct. Same.
Then how can there be two different findings?
Yes, that's why, my lord, we filed this appeal.
No representation for the respondent, counsel for the appellant is present. List this matter as part heard on Wednesday. Then next.
Cell number 9.
My lord, in this case, my lord, my name may be deleted, my lord. Since your lordship has ordered for issue of notice to R2 and they have to pay the PF.
D. Vijay Kumar, we cannot file.
Even he has not furnished the copy of the appeal memo also and not taken the process also.
No representation for the appellant. This is matter tomorrow for dismissal. No, that's what you, Wednesday or Thursday.
8.
Yes, 10.
Cell number 10. Cell number 10.
Appearing for the
N.
appellant, my
Krishna
lord.
Swamy.
The cost of suit, the cost imposed by the honorable court is paid, my lord, cost today.
It's paid.
Yes, my lord.
It is submitted that they've already paid the cost as ordered by this court dated 27/2. Why the cost?
Steps is not taken.
By on 27/2/2025.
So within a week, I'll take necessary steps, my lord.
For what?
Venkatagowda.
Respondents
You should have done it for that costs are imposed. You should do that and then come to the court. How can you say 1 week?
My couple of the days I will.
In the course of the day, the steps shall be taken. List this matter. This in June 19th.
Cell number 11.
Much obliged.
I appear for the fourth respondent.
You appear for the
Fourth respondent.
R2. What is the abate service of notice in respect of R2?
R2 liability has passed on the KSRTC, madam.
I'm for the appellant, my lords.
No, then why it talks about the notice? Mr. Dabali is there. Where
Yeah.
is Mr. Dabali?
FS double A for R2.
Is this matter, no representation for the respondent. Is this matter on,
I represent fourth respondent.
no, second.
Second as well.
No representation with the second respondent. Is this matter on 16th of June? Yes, next.
Cell number
Much
12,
obliged.
MR Shalmala.
This case, respondent to is placed ex parte before the court.
File a
below.
memo if you don't want.
I have
notice to-
filed on earlier occasion itself.
A memo is, look at it. If not, give it, write it and give it now.
I will.
A
I
memo
will.
is filed seeking dispensation of notice to R2 or stated that he has been set ex parte before the trial court, the tribunal accordingly. Memo is taken on record and same dispense with the risk of appellant. Yes, next. Is this matter for final hearing in the month of August?
For admission, no? Not
Admit.
On submission, my
Admit to
lordship
final
may be ordered to pass,
Huh?
to serve copy, my lordship, respond number 3.
Serve a copy on him. Then counsel shall serve the copy of the appeal made on the counsel for the respondent during the course of the day. Admit post for final hearing.
Please, my lordship.
Yes, 13.
13,
For appellant in this case,
Suresh
my lord,
Amlator.
we
Who
have
is
taken
R2?
steps 2 times, my lord.
Huh?
We have taken steps 2 times, my lord. It's not served. Address the left. It's R2 is the insurance, my lord. So
R2 is the insurance company.
Yes,
We will appoint somebody. Which insurance company?
It is Bharti AXA.
Bharti Axa, my lord.
Huh?
Bharti Axa.
AXA.
Bharati AXA.
Manager Bharti AXA General Insurance.
Mr. Pradeep is directed to take notice on behalf of the respondent insurance company and the land counsel for the petition shall serve the copy of the appeal memo today itself during the course of the day. Admit list this matter for final hearing.
Cell number 14,
For appellant, my lordship,
Memo for
beginning LRs, my lordship, I file application, my lordship.
for dispensation of notice.
Memo
to
is for seeking dispensation of notice to R1 same and there is next
dispensed.
IA 1 of 24 is 336 days on condition. Oh, it is, notice is ordered, IA,
Notice is order, my lord.
Notice
Okay.
look at it, notice is served.
BC Shone Goda.
application, sir.
We filed LR application, LR application we have not.
Who died?
That is died, my lord.
Appellant died.
Please, my lord.
His notice not required. He is, who died? Appellant died.
Appellant.
Appellant, my lord.
IA number 1 is filed to condone the delay of so and so in filing the LR application. For the reason stated, the delay is condoned. Delay is condoned. And IA number 2 of 24 is allowed by setting aside the abatement. And consequentially, IA number 3 of 24 is also allowed and the petition shall make necessary amendments to the cost title. This
Cell
next.
number 15, Kavita SC for appellant.
I am for respond number 2, my lord.
During the course of the day, I am required to pay process fee to the
Process
respondent.
shall be paid during the course of the day or else the appeal shall stand dismissed.
Much
Yes.
obliged.
16 hearing on interrupted applications. 16,
Appear
Gita
for the respondent's counsel, my lord. 1,83,000 rupees is awarded by the trial court. 50% has been ordered to be deposited before the tribunal. I am informed that it has been deposited.
No, whether they are on liability,
The appeal has been filed on liability.
in that case, in those cases, we will not order
Now,
release of
my
the amount.
only submission is, my lord, records may be called for. It is just 200 kilometers from away. The party is in utter difficulty. There was a flood in his house and his house is under completely repair. He is in debts now. If a date is given for next
What
week,
is-
the
on
matter
what
can.
ground you are before this court?
Maintainability of the claim petition itself is challenged by the insurance company for the reason no complaint was registered, no FIR was registered, no charge sheet, no wound certificate. Only on the basis of medical records, the claim petition came to be filed before the tribunal. And the tribunal, there is, I would, Rule 232 of Karnataka Motor Vehicle Rules.
IA number 1024 is filed for release of the amount, and the insurance company is before this court on the maintainability of the claim petition itself. As such, this court is not inclined to pass any order for withdrawal of the amount. Accordingly, IA number 1025 is dismissed. The trial court is, the registry is directed to call for the TCR. Yes, admit post for final hearing.
Date may kindly be given.
Because there are, the court is not hearing.
16th may be given.
Not this side of the vacation.
No, madam, only submission is, otherwise I would not have insisted.
Under these circumstances, do you think that you can succeed in the appeal?
No,
That's
my
why
lord.
I asked her,
No, my lord.
if there is any point, I wanted to, hear it.
No, my
now
lord,
itself.
subsequently there is FIR has been registered. Subsequently there has been a.
Part of the record.
It is all part of the record.
No,
The
no,
trial
it was
court has
not the part
considered.
of trial
The
court
trial
record.
court has considered every
No,
point. I have read the
kindly-
file. My only submission is, my lord,
The judgment may be. looked
respondent
into, my
number one
lords.
submits that.
No,
Let's see the exhibits.
exhibits,
What are
my
the
lords.
Exhibits
It
that
is
are
at
marked.
internal page 22 of the judgment. Discharge summary, medical bills, lab reports, prescription, X-rays.
MLC. Intimation
Nothing is produced,
by
my
doctor
lords.
to the police.
And accident takes place in Maharashtra and he
Inti-
comes and files a claim petition.
That is
in
no bar, my
Viraj.
lord. That is no bar.
And there is no
Any-
complaint at all.
Intimation by
Very
doctor to
involvement
the
of the
police.
So if you say that there are subsequent documents, only courts available is to remand the matter.
My submission is on 16th, I will take only 10 minutes to submit, my lord. The matter can be disposed of. It will not take more than 20 minutes, my lord, for the matter.
There's this matter on 24th of June.
Obliged.
Much obliged. Grateful minutes.
Cell number,
Yes.
cell number 17 for admission matters.
What is the letter?
Yes, yes. Chantraj.
It's a letter. Letter dated 17/11/2023 is coming up now. How can it be? What are they doing for these many years? Hmm. When is that? No, that's what I'm saying. It is over, sir. The letter that is addressed by the court seeking time is on 17/11/2023. And the matter is placed before this court today. The letter is placed before this court today. By this time, the matter itself must have been disposed of. Hence, no further orders required. Oh, this is the one Ravi Sampati was saying the other day. Yes, no representation on behalf of both the parties. This matter on 26th of June. Yes,
26th of April. Cell
or
number-
else admit post for final hearing.
Ah.
Yes, next 18.
Cell number 18.
Yes, admit post for final hearing.
Lord, 18, my lord. Claimants, my lord, are aggrieved. My lord may kindly fix a matter for hearing. My lord. Next week, one date may please be given. 10-year-old appeal.
Where is he?
Lord,
Usually comes online, my lord, but today there is a network issue.
they are,
Then we'll have it on 16.
please, please.
Yes.
Cell number 19 adjourned. Cell number 20.
Number 19, I placed, no, responded to it.
19,
Yes, what
Sita
the-
Ramarao is not well, it seems.
That he
I
is
made a
the-
mention, I told him to inform the other side also. Yes, 20.
20. MV
20, your lordship, they
Maheshwarappa.
appear for appellant. Case of head injuries, your lordship. Copy served to the respondent counsel.
Where is Mr. Lingaraj?
Lingaraj,
Ask him to come, we'll take up.
Right.
Oh, it is a 21 matter.
Yes.
Admit post for final hearing.
Date may be given. The
Date
head
will be
injuries,
given.
your lordship kindly photograph the.
August. Give a date in August. Yes, next.
4/8. List number
Yes.
2 for dismissal, serial number 1, Usha Devi KG,
Appearing
for
for
a petitioner, Mahendra G.
Yes.
I seeking for the transfer from Madvalli to the Rani Bennur, my lord.
Why were you not present yesterday?
Sorry, my lord, I was held up in some other hotel, my lord. Unable to enter in time, my lord.
Speaking from transfer from where to where?
Seeking for transfer from Madvalli to Rani Bennur, my lord.
Rani Bennur.
Yes, my lord.
What is the distance?
Matrimonial dispute, my lord.
Distance.
Distance 350 kilometers, my lord, one side.
Children?
Children, no children.
MC of which year?
MC is 23, my lord.
Stay is granted in this?
No, my lord.
Then what is the present stage of the proceedings? That is important.
Stay is granted, my lord.
That's what I'm asking. Is a stay granted by this court?
Yes, my lord.
When was it?
On 7/11/2024, my lord.
Miscellaneous of 2022.
Yes, my
You
lord.
come before this court in 2024.
Yes, my lord.
What has happened till then?
No, my lord. They filed MC petition in 23, my lord. 66/23, my lord. They filed a petition before Madvalli, my lord. I filed a miscellaneous petition in Rani Bennur in 22, my lord. My petition is pending in Rani Bennur, my lord.
Present petition is filed seeking transfer of MC number 66 of 2023 pending on the file of the senior civil judge and JMFC at Malvalli to the Court of Senior Civil Judge and JMFC at Rani Bennur. The facts of the case are the marriage are taking place on 21/3/2021. In view of the differences between the parties, the wife started residing with Rani Bennur and filed a criminal miscellaneous 335 of 2022 under section 125 1 and 2 of CRPC seeking for maintenance. Thereafter, on 11/8/2023, the husband has filed a petition seeking dissolution of marriage, that is MC number
66/23
on the file of the senior civil judge at JMSC Malavalli, Mandya. And counsel appearing for the petition submits that the distance between both the places is about 350 kilometers, and it's very difficult for the wife to travel on each date of hearing. Next para. Though there is no representation on behalf of the respondents. Next para. Considering the submission of the written counsel for the petition and considering the.
For the respondent.
What do you say?
The transfer petition filed by the wife. What's the matrimonial life of 6 days? Now,
We are not on the merits of the matter. We are on the 350 kilometers, the distance between both the places. And already a criminal miscellaneous is pending at that place, at Rani Bennur. You can contest both. Land counsel appearing for the respondent submits that the married life had lasted only for a very short time, and he submits that if the matter is transferred, it would cause inconvenience to the husband. Next part. Considering the fact that the distance between the places is 80 kilometers and already a criminal miscellaneous is instituted by the wife in the year 2022 at the courts at Rani Bennur, this court deems it appropriate to allow the petition. Same conditions, wife should cooperate and all. Yes.
Two, Sunil Kumar Patel.
My lords, I appear for petitioner in this matter, my lord.
Yes.
My lords, needful has been done, my lords. I have taken the process today morning. I'm sorry, yesterday I could not appear because I was on legs in some other court, my lords.
No, take out notice on the counsel appearing for the respondent.
Certainly, my lords. Certainly, my lords.
And someone appearing for the respondent.
Yes,
And
yes.
a memo shall be filed before this court by today is, shall be filed before this court by 23rd of April. If the memo is filed, this is matter on 24th. Stay is there.
Stay is there, my lords, on 16/1/25.
If the memo is not filed by 23rd, the stay granted by this court dated so and so shall stand vacated.
It was not extended in the last date of hearing, my lords.
It's not extended.
It was not extended because your lordship were not sitting on the other day. So the matter called before some other court, it may be extended, my lords.
The interim order granted on so and so is extended, and the stay granted will be vacated by so and so. Yes,
Please,
next.
please.
Channel
Much of.
3,
I appear for the petitioner, my lord.
Kumar Gowda, for petitioner.
My lord, here the petitioner seeking to transfer the MC petition from
What is the
Sakleshpur,
maintainability issue?
seeking transfer within the district is the maintainability issue.
You could have as well asked the same court. Why have you come to the High Court? When there is a remedy available to you, why should you come here?
That liberty may be reserved.
You will go there. You're seeking transfer from where to where?
Seeking transfer from Sakleshpura to Asan district, my lord. Sakleshpura Taluk to Asan district.
Sakleshpura. What is the distance between both the places?
My lord, around 45 kilometers is there, my lord. And the wife has filed the petition
office
before.
has taken the objection with regard to maintainability. Then council submits that the court has the concurrent jurisdiction to entertain the petition. Accordingly, the office objection is overruled. Considering the difficulties, considering the reasons, it is submitted that the distance between both the places is 45 kilometers and it is difficult for the wife to travel. Considering the same, there shall be stay of all further proceedings. And so and so, so and so. Same hand summons.
Much.
By 23rd, 22nd, you should file a memo. 23rd, you should file a memo. And if it is filed, list on 24th, or else the stay granted by this court stands vacated. Yes, next. 4.
Number 4. Anjaneya for petitioner.
As there is no representation on so and so, the matter was directed to be listed today under the caption for dismissal. Today also there is no representation. Accordingly, the appeal is dismissed for non-prosecution.
Chair number 5 for orders matter. Shankar Narayan Bhatt.
When is the notice sent?
Notice.
Where is the council? No representation. This is matter for dismissal on 8th of April. Yes, next.
Chair
Not
number
8th,
6.
list on 9.
9.
Yes, 6.
6. Spurti Hegde, furnishing of portal cover.
Same, this also on 9th for dismissal, no representation. Yes.
Chair number 7.
I appear for petitioner in this matter, my lord. My lord, the parties have settled the matter
It is
outside court.
submitted, a memo is filed stating that the parties have settled the dispute. Hence, they want to withdraw the petition, accordingly dismissed as well.
Obliged.
Next.
Chair number 8. Chair number 8.
No representation for dismissal.
9-4.
Yes.
Chair number 9.
Appearing for the appellant in this matter, my lord. I filed a memo for dispensation for respondent
Take
number
that.
5 to 12, my lord.
5 to
12, my lord, regarding respondent number 2, 3 and 4 is
a memo
concerned.
is filed seeking dispensation of notice to respondents 5 to 12. As it stated that they have placed ex parte before the trial court.
Respondent-
The memo is taken on record and the notice to respondents 5 to 10 is dispensed with. Then
My lord, regarding respondent number 2, 3 and 4 is concerned, I will take out notice to the advocate before the first appellate
you
court.
want to take.
Please, my lord.
The petition is permitted to, the appellant is permitted to take out notice on the counsel appearing before the trial court for respondents 2, 3 and 4 and shall file a memo to that effect by 28th of April.
My lord, kindly short date may be given, my lord. This is matter, my lord, third time litigation.
If you want to file, no objection to the court, 21st of April.
Please.
Yes.
Serial number 10.
My lord, regarding respond number 11 is concerned, he was died. My lord, he is also not necessary party. My lord, he is appear, but he is not expected before the trial court.
Whatever it is, if you say, then I will record.
Please.
There should be a memo on record,
Please,
not a oral submission.
please, my lord.
Next time you do that.
Already, my lord, application was filed. The application is not survived. My lord, I will dispensation also in respond number 11 also.
Fine.
Already mentioned in this matter. Memo.
This, in this memo. Give that memo.
Respond number 11 is died.
Let me look at it. It is stated that in the memo only. In the memo, it is stated that respondent number 11 is no more, and he is not a necessary party for disposal of the present application. Same at the risk of appellant.
Application may be not survived. I have filed an application for bringing LRs. That application is not survived.
The same. Where is that application? IA number?
IA number 1/25, my lord, 1, 2, 3.
IA number 1/20. In view of the same, in the as the appellant had sought for dispensation to the heirs of R11 and stated that they are not proper and necessary parties. I number 1, 2, and 3 does not survive for consideration. Needs no consideration.
Please, oblige.
Serial number 10.
Sure, petitioner, my lord, kindly pass over.
Non-filing of the proof of document of trial court or appellate court to verify the name of appellant. That is Roshan R.
My lord.
Pass over. Yes.
Serial number 11. C. Shankar Reddy.
Appearing for appellant, my lord, grant 2 weeks time to take necessary steps to.
This memo is filed on 5/2/25. Where are we now? Why do you want time? Is there any interim order in this?
Yes, my lord.
Then we will vacate that interim order.
At least 2 days time, my lord.
Finally, a week's time is granted for taking steps in respect of the deceased R1, or else the appeal shall stand dismissed. The stay granted by this court stands vacated.
Interim order can leave. Interim order.
Interim order earlier granted is extended till the next date of hearing. Yes.
Serial number 12. A.M. Venkatesh.
Appearing for the petition.
What is this RP of 2008?
Appear for the respondent. Claimant appeal was disposed of by this court, enhancing coverage to the extent of 78,000, apart from what is granted by the learned MH. Without connecting my appeal, which is questioned on liability, that is been disposed of. Hence, this RP is filed before this court.
Who is R1?
R1 is the claimant, madam.
You appear?
Yes, madam. In the connected matter, I appearing.
Then you will take notice.
I will take and
Then
direct them to
counsel
furnish
for
set
so-
of copies.
What is your name?
Naik Ramchandra.
Naik Ramchandra Rama submits that he is taking notice for R1 and he'll file the wakalat. Registry is directed to pin the name of Mr. Naik Ramchandra Rama for R1. Any delay in this?
Yes, madam. There is a
52 days delay in filing the
Direct them to
appeal.
survey set up copy.
Huh?
Direct them to survey set up.
And counsel for the appellant shall serve the counsel for the petition shall serve the copy of the memo petition on the counsel for the respondent during the course of the day. The delay of IA number 1 of 2008 is filed to condone the delay of 52 days. For the reason stated, the delay is condoned. Admit or not admit, list this matter or admit post for final hearing in the month of July.
Please.
Yes, next.
List number 3. Serial number 13.
Appeal for petition. In this case, my lord, the respondents had filed an application for rejection of plaint that was allowed by this honorable court. By challenging that, we have filed a original second appeal, my lord, that was allowed. By challenging that, they had filed SLP.
SLP is filed. In the SLP, stay is granted.
Stay is granted, my lord. So it may be
We
adjourned.
will file the memo.
It is submitted that against an interim order you went.
Yes.
Against the final order
Final
passed in
order.
original side appeal, my lord.
It is submitted that the Honorable Apex Court in SLP number 8347 of 2025 had granted stay of the order passed in OSA number 9 of 2024. In view of the same, does this matter after 3 months?
After 4 weeks, my lord,
This matter in the month of July.
please.
Yes, next.
Cell number 14. Cell number 14. Fayez Jayasima for
My lords, we haven't received the documents attached to the IA that is
Yes,
filed
please,
by
my
the
lord.
plaintiff.
Even I have not received.
And in fact, we've emailed them, called them, but they have not yet
Any
given us
interim
a
order
call.
in this?
No, my lords, it's a TOS, it's for recording evidence.
No representation for the appellant, let's this matter.
My lords, a
You
short
have, you have
date
no
meeting.
urgency.
My lords, there is some urgency. My lords, past 1 year, the evidence is being recorded. There has been no progress.
After, on 17th of June.
My lords, may I request before, because it has to go back before the registrar, my lords, for recording evidence. This is only for production of additional documents, IA.
Matter on 28th.
Please.
Grateful.
Yes, April. Yes, next 15.
Cell number 15. Anil R.
Appearing for petitioners, my lord. Petitioner is seeking transfer from Nanjangoodu to Mysore, my
IA
lord.
number 1 of 2025 is filed, seeking dispensation of production of the certified copy in MC number 52 of 2021 dated 15 to 2025 and 1325 and MC number 804 of 2021 dated 3/3/2025. Considering the reasons stated, the IA number 1 of 2025.
There is a stay application, my lords.
IA 1 of 2025 is dispensed with. First, we have to see the other one, then we will see the stay petition. Give the file. Yes, from
Appearing for petitioners, my lord. Petitioner is seeking transfer from Nanjangoodu to Mysore, my lords.
On what ground?
On what the respondent is appearing in Mysore Family Court for maintenance case and only 20 kilometers. I filed divorce petition in Mysore Family Court. After I filed.
Come to the prayer portion. So you're seeking transfer of MC number 52.
52/2021 to
filed by the respondent.
Filed by the respondent.
Where she filed?
In Nanjangoodu, my lords. I filed in MC petition 804/2021 in annexure, my lord. Annexure C in Mysore Family Court. I filed for divorce. She filed for restitution of conjugal rights. There is a parallel proceedings. Instead of filing the counterclaim in Mysore Family Court, she filed in Nanjangoodu Family
We
Court.
will transfer your case to her court.
No, my lords, because she is already attending for this one maintenance case to Mysore only, my lords.
Take out notice.
No, my lords, there is already a stay in another case, my lords. Hence, it is very much necessary.
What is another case?
Another case, MC 804. I was challenging IA number 10, my lords. There is a stay in that case. So in this case also it stays very much necessary, my lords.
I'm not able to understand. Transfer petition is altogether a different issue.
Not different issue with the same parties. The same case, my lords, MC 804, where I am seeking for transfer. This Honorable High Court granted stay order in 804.
Along with that on Tuesday.
No, my lords, kindly grant the stay order, my lords. It is very much necessary, my lords.
Let's this matter on Tuesday along with that other transfer petition. Yes, next.
Cell number 16.
That's good.
A.S. Chandra.
Yes.
I'm for the petition.
I want to appeal for vacating the interim orders.
The first, that is IA number 2, my lord. It is for deposit of admitted arrears of rent from 1/7/2024 to up to date. I have filed an application and without that permission, without the leave of this court, in the office they are not accepting. Therefore, I filed this application.
That the
That IA 2 of 25 for permission to deposit the arrears of rent.
arrears of rent.
Arrears of rent from
Arrears
when
of-
to when?
From 1/7.
It is 2000, my lord. The written statement which they have filed, they have admitted is 2000, not 150. At the time inception it was 150, not now. I've got the statement which they have filed.
In their
in para
evidence
number
and
3.
also order, there is no contention about the arrears of rent at all.
I think.
And it is not the case that there is arrears of rent.
My
And
petition,
only after
1 minute, 1 minute.
they have filed the statement, they've admitted 2,000.
There shall be stay of operation of execution of the impugned order, so and so, at liberty to move this court for vacating the stay. No, it
No.
is like this.
No.
1
I-
minute. He has filed an application to deposit the arrears of rent according to him, so and so. First of all, let him deposit the amount. You will not lose anything. Then you can come up before the court saying that these are not the amounts. They have to pay from so and so date, isn't it?
Yes.
So first of all, we'll allow his application. We'll permit him to deposit. We'll consider your application. Let him come up with a reply to your objections to your application.
My lord, my only submission is, your lordship can take to this petition copy they have filed, they're ready to vacate. What they're saying, I'm not concerned much about the rent because we have 4 siblings. We have got an agreement to build and reconstruct. I got a plan signed, plan is already expired, my lord. And this is what they say in para number 10. You pay my 1 lakh. They say they have paid 1 lakh advance, you pay, I will vacate. That's the statement she has made in the statement. You want to see para number 10. What I've said there.
Then, but this court cannot hear this matter at the, for the fag end of the vacation, final hearing.
Okay. Then may I request lordship to have it Tuesday and I'll check and file my application for my lord, because the urgency is they are all living their own rented houses. We have got a plan sanction. Plan is expired, my lord. Now the present fee that is payable for the building is on the guideline value.
This is matter on 25th.
20.
Meanwhile, I may be.
No, that is, there is no urgency for it.
Going to be
20.
25th.
And I may be permitted to file the amended petition, my lord, because I have deleted the other respondents.
You are at liberty to file it
Yes.
when you delete, permission is granted for deletion. Yes.
Seeking enhancement of the compensation, my lord.
They may be extended, my lord, till 10th.
That's what he's saying, a transfer petition it is.
My lords, one submission, my lord, that is WP, my lords.
And then you are saying
Because I'm saying that in that case,
that's what I
WP,
said.
then I inform my lords.
Staying by this court on an IA.
This high court, I said, my lord, it's a WP.
Will not take, the petition is permitted to take out hand summons on the counsel appearing for the respondent before the
My
trial
lords,
court.
kindly grant stay order, my lords.
Shall
Because
file
day
it.
after tomorrow it is a case, my lords.
Go there, shall
No,
file
my
a memo
lords.
to that effect by 22nd, if that is filed by 22nd, list is matter on 23rd. Yes.
Cell number 17.
Seeking enhancement of the compensation, my lord. In this
79,
case, beneficiary is not made as a party.
Seventy.
Consistently remained with the matter.
Cell number 17.
Where is the counsel?
Council implementing application is,
Ask Mr. Prashant to come, will.
it is served, my lord.
Huh?
It is served, implementing application is served on Kaveri Engineer, Kaveri Niravari Nigam, my lord.
That's what I'm saying. Ask Mr. Prashant to come, afternoon will pass order.
Please, your.
Pass yours. Cell number 18. Cell number 18.
Happy for the petition.
Gautam Raghunath.
Lords, in this matter,
Yes.
I'm seeking for the transfer of the case, my lords, from Kolar to Bangalore. That is the
Not to
reason.
Bangalore.
Please, my lords. The reason being, my lords, now this couple, they had 3 kids, my lords. 2 of them died. 1 remained. That the custody is with the petitioner now, who's the mother, who's residing in Bangalore, and the kid is also studying in Bangalore. This matter is in Kolar. She being a maid who works as a servant, my lords, who being a maid, it's very difficult for her to, with very less income, to travel from Bangalore to Kolar.
Matter is already disposed. They have yesterday. Matter is already disposed. I think in the 20, GNWC 12 of 18.
Oh, the main petition itself is disposed of.
Judgment is there. I have filed wakalat yesterday, day before yesterday. I have to take the petition.
Filed a wakalat day before yesterday. What is
In what? In which case this
in
case?
this case? Yeah, filed.
You want to file your objections?
Yes, Lordship. That main petition, GNWC 12 of 2018, is already disposed on 7th January 2020.
7th January?
2020.
Or will they file a transfer petition for a disposed of case? Maybe something.
This is the petition.
GNWC number 12 of 2018.
Please, my lords. I'll seek instruction and revert back.
How, if it is really disposed of,
Please, ma'am.
how can you file a petition? Look at it, pass over.
Please, ma'am.
Serial
Yes,
number
next.
19. Mohammadeshwar Rao, a petitioner.
Non-filing of an
Affidavit
affidavit.
is filed.
Filed ಮಾಡಿದ.
Yesterday affidavit.
Yes.
You
Facts.
received.
Now they have filed objection to the,
ಅಲ್ಲ ಇದರಲ್ಲಿ
objection to the affidavit.
No, let me first understand.
Please.
CP 529 of 2024
Yes.
is filed by
Husband.
Wife,
Appear,
wife. I'm appearing for wife.
529 is by husband
yes.
to transfer the petition filed by the wife at Shivamogga. To Bangalore, where he has filed a MC for divorce,
What are the reasons for that?
for transfer. Now, the reason is that now his mother and father are not keeping well and they are suffering from, mother is suffering from coronary heart disease. Father, you have produced the medical document. And there is a threat of life to the petitioner if we go to Shivamogga where petition is filed in the two complaints.
But, last time also I asked whether
Yes.
any complaint is filed before the police
Yes.
stating the threat to the life.
No, police complaint R2. If you are also taken file CP 409 of 2024.
When did you give the complaint?
Now, the two complaint has been one 15/9/2024, 26/2024, page number 19 of the objection filed in 409. Same documents were produced in the other case also.
Yes.
Now, after I filed a petition for divorce. Petition as a counterblast case has been filed in Shivamogga. And your lordship, last time I have produced the application as appointment order of the respondent
Where?
in this writ petition.
No.
Sorry, in this petition, she was employed in Bangalore.
Bangalore.
Yes. And your lordship has accepted to file a affidavit regarding her employment in Bangalore. But a copy has been served. With regard to in this affidavit, she has not stated when she has joined the duty and she has relieved from the duty. And on the other hand, she has made false allegation about the harassment and other allegations which are not necessary. However, because an affidavit has been filed containing certain allegation against the petitioner and his parents, I may be permitted to file objection to the counter to that, because it should not go that I have not.
Relevant, why are you find all that?
That
Court asked you to file an affidavit
Please,
for specific purpose.
Please.
Then why are they necessary? Is this court going to decide all that?
Not-
What is the harassment and all?
No, Miller.
And in the affidavit, nowhere
Where is your affidavit?
Affidavit yesterday.
Look at it. What affidavit file?
affidavit, first page, last 3 to 4 lines.
1 minute. Yes, what is affidavit? She filed an affidavit saying that she is not working.
No, but the affidavit is very vague because she has not stated when she has joined, when she has relieved, and no document has been produced to show. Because she was appointed as a business development manager on 6/5/2024, annexure R6, page
So here we
48.
are not conducting any trial.
No, of course.
No, no.
That therefore
Affidavit,
this.
they have stated that she is not working.
Now,
We take
since
it for-
certain allegations has been made,
That
I may be permitted to file objection that
File
copy
your
is served.
objections, we'll say that will not consider all that. Take
This
that.
objection will be placed on record just to, as a matter of fact.
Yes.
Second, so far as the transfer of the petition from Shivamogga to Bangalore is concerned, page number 19 of the objection of PLC.
Yes.
Now, we have given a police complaint that the wife along with other persons, 8 to 10 people forcibly break through their home and creating rucks on the, because they are staying in the apartment and sought for police protection from them. Secondly, another complaint was on 15/9/2024. So both the complaints, the police have taken cognizance, but they have not proceeded further. And I have produced the medical document also, right from, you can see the medical document of the parents.
We
of the-
understand that
Yes.
ailment of your parents.
Yes.
Yes.
Now, annexure, page 31, that is the parent, the father of the matter, and also that mother. Therefore, he is the only son in Bangalore and taking care of the aged parents. And the wife is capable to travel from Shivamogga to Bangalore because there are connectivity of train and buses, and petitioner is ready to bear the expenses to and fro. Now, as a counterblast case has been filed, and now that see the conduct of the wife. 2 dates. He went to the Shivamogga to attend the conciliation. She has not turned up. She said that she is staying with her parents in Shivamogga. So this is nothing but to harass the respondent. As a counterblast case has been filed after filing of the divorce case by the husband at
What is the case she filed there? Restitution.
restitution in Shivamogga. Divorce at it.
Yes.
My lord, whatever the allegation is made is false, my lord. I have stated in my affidavit that I.
No, apart from that affidavit, when he says that there's a threat to his life and he has already given a complaint, what do you say
Lord,
on
may
that?
kindly see the date of appointment order, my lord. This 6
Not
May
date of appointment.
6 May
I'm saying threat to his life.
No, I tried to reunion the husband, my lord, but I am not allowed to enter the house.
He's saying threat when
There
he
is no-
came to Shivamogga.
No, there is no threat. There is no complaint is lodged in the Shivamogga. These are complaints lodged in Bangalore.
Where is that? Page number?
Page number 14, my lord.
Page number 19 in the objection.
14, my lord.
Now 14, of course, it is in Kannada.
Page number
Typed
14.
copy is in 19.
Acknowledgement issued by the police, my lord.
So and so. According to him, where this incident has happened?
According to them, it is happened in Bangalore, my lord.
Is it so?
Yes.
Yes.
Bangalore, they came with 8 to 10 people and forcibly tried to break through. And this is the apartment. They went to the office of the apartment owner.
That means you have a threat in Bangalore.
No. Now, when the threat is in Bangalore, when we are staying in Bangalore, There will be more threat in the Shivamogga where they are permanent, according to them, they are residing and they are entitled to.
Both the wife and the husband have filed two petitions. That is, the husband's petition is CP 529 of 2024 and the wife's petition is CP 409 of 2024. Husband has instituted MC number 5439 of 2024 on the file of the family court, instituted MC seeking divorce on the file of the 6th additional principal judge family court at Bangalore. The wife had filed MC number. What is the number?
327 of 2020.
She had filed. Give the other file.
327 of 2024 at family court Shivamogga.
Wife had filed MC number 327 of 2024 on the file of the family court at Shivamogga seeking restitution of conjugal rights. It is submitted with the learned counsel appearing for the husband that he has to take care of his parents and both of them are suffering with health ailments and he has filed the medical records in support of the same. It is his case that wife is working in Bangalore. Hence, his court has directed the land council, directed the wife to file an affidavit in that regard. An affidavit is filed before this court stating that she is staying at Shivamogga. Earlier, she used to work at Bangalore, and at present, it is not working. And she has also made certain allegations about how she has been treated. For that, a reply is filed by the land council appearing for the for the husband, stating that all these allegations are irrelevant, and the purpose for which the application was asked to be filed is about her, whether she is working in Bangalore or not. And he is denying all the allegations that are made. It is also submitted with the land counsel appearing for the husband that there was an assault on him by the wife and her relatives. In that regard, he has already given complaint on 2/6/2024 and 15/9/2024. It is submitted that if he goes to Shivamogga to attend the case there is threat to his life. Hence, considering it is also submitted that he is ready to pay the traveling expenses of the wife. She travels from Shivamogga to Bangalore. It is submitted that under these circumstances, the pending MC on the file of the family court at Shivamogga will be transferred to the family court at Bangalore. Learned counsel appearing for the wife submits that the wife wanted to join the husband, and in that regard, when they approached the husband has given this complaint at Bangalore. It is submitted that wife is working in Shivamogga. A wife is not working in Bangalore, and that in that regard, they have an affidavit is already placed on record. It is submitted that the distance between both the places
About 270 kilometers.
300 kilometers.
distance between both the places is about 300 kilometers, and it is difficult for the wife to travel from Shivamogga to Bangalore. It is submitted that the MC pending on the file of the family court Bangalore may be transferred to Shivamogga. Next para. Having heard the learned counsels on either side, produce the material on record. The husband had filed the MC in Bangalore seeking divorce, and the wife had filed the MC seeking restitution of conjugal rights at Shivamogga. Now she has filed an affidavit before this court that she is not working in Bangalore and she is in Shivamogga staying along with her parents. The distance between the places is about 300 kilometers. Further, the contention of the learned counsel appearing for the husband with regard to the threat the, it is not at Shimoga, and according to him, they have threatened, it has happened in Bangalore. Hence, that threat perception cannot be a ground not to transfer the matter, from Bangalore to, not to transfer the matter from Bangalore to Shimoga. Further, the health ailment of the parents, he'll be going to Shimoga during the course of the day, and at the same time, during the course, he'll be outside in the office taking care of his professional work. That cannot be a ground, cannot be a ground to either to transfer the case from Shimoga to Bangalore, or not to transfer the case from Bangalore to Shimoga. Hence, considering the fact that the distance between both the places is about 300 kilometers, and the wife is staying along with the parents at Shimoga, this court deems it appropriate to transfer the pending MC and the file of the family court at Bangalore to withdraw the case at so-and-so and transfer the same to Shimoga. Accordingly, the application filed by the husband, that is CP 529 of 2024, is dismissed, and the application filed by the wife, CP 409, is allowed. Yes, next.
Cell number 20. KV Satish Chandra for petitioner. Chitralekha.
It is from Davangere to.
In this case, my lord, I have filed the wakalat yesterday. I praise time to file an objection to.
Time is granted for filing objections. List this matter on 22nd. Intermodal earlier granted is extended.
Much.
One. Leela Krishna.
My lord, the wife has filed the transfer petition, my lord. The husband has filed for divorce in Anekal. She is seeking for transfer from Anekal to Hosadurga, where she has filed for maintenance under the DV Act, my lord. My lord, the distance between these places is around 250 kilometers. There is a 5-year-old son, my lord, and she's working as a maid, my lord. That too, she's joined recently. She's
The petition is filed seeking transfer of MC of 2021.
Yes, my lord. She's not been able to contest the matter at all. It is posted for petitioner evidence, cross-examination, but she's not even filed her objection because of an inability to.
What is she doing from 2021 to 2025?
My lord, nothing has progressed in the matter also, my lord. Because
it's not about nothing progressed.
Yes, my lord.
The fact is, what are you doing? Why are you keeping quiet from 2021 till 2025?
My lord.
Then now also you keep quiet.
If I may,
the matter will
no,
be
my
completed.
lord, if I may submit, my lord. Even my instruction was that she was not able to communicate with the advocate in Bangalore, the person
You
who
could communicate to the advocate in Bangalore. Why not there?
Yes, my lord. That there is some great difficulty that she's been facing, my lord. Then
We cannot transfer cases which are pending, which are filed in 2021.
no, my lord. My lord, if I may take your lordships to the order sheet. If your lordship see, my lord, it is just posted for cross-examination of petition. She's not been able to prosecute, my lord, because she's working as a maid. There's no.
Why did she not go? That's the question. Why did she not, when she knows that the matter is pending, why is she keeping quiet? Why is she not appearing before the court? And why she moved a transfer petition before this court?
That is because
then when she has no respect to the orders of the court, when there is a notice to her, she should do something.
My lord,
or she should have done it at the earliest.
My lord, she has appeared there, my lord, 1 or 2 times, but she's not been able to file her objections. She's not been able to attend the court, my lord, because, my lord, she does not have, she's 12th fail, my lord, and she does not even have the normal knowledge regarding this legal proceedings as well. I then had to communicate with her advocate in Hosadurga and take out the information as well. That is a serious problem, my lord.
When the trial has commenced, why should we transfer it?
My lord, there's already a maintenance case, a DV case pending in.
Maybe.
Yes, my lord.
Maybe.
Well, but there's great difficulty, my lord. She's not been able to take care of the matter here. If it is transferred there, my lord, maybe that advocate there will be able to effectively prosecute the case.
Why the advocates there can't prosecute?
My lord, because of the financial, my lord, admittedly, my lord, the cost of litigation in Bangalore and in Hosadurga would be different, my lord.
No, we will be sending the wrong message if we allow these applications for an MC of 21 transfer in 25. Court has all sympathies for your client, but there is a procedure for everything.
My lord, it's my humble submission that if it is transferred, there is high chances that it can even be resolved there, my lord.
What has happened to the notice to respondent?
He has not appeared, my lord.
How
He's
will he
refused
serve?
it.
When it is served?
He's refused notice.
You have taken hand summons. He refused it. The present MC is filed seeking transfer of MC number 74 of 2021 pending on the file of second edition senior civil judge at JMFC Anakal, Bangalore Rural, and transfer the same to the court of the senior civil judge and JMFC Hosturga. It is submitted that the wife is working as a maid and eking her livelihood and is difficult to travel. How much is the distance?
250 kilometers.
250 kilometers from so-and-so to so-and-so. When the matter came up on the last occasion, this court had directed issue of notice to the respondent. Now, as per the postal shara, the respondent had refused to receive the notice, and the court has held that it amounts to in service of notice. It appears that a respondent has no objection to transfer the matter from so-and-so to so-and-so. In view of the same, so-and-so.
Grateful.
Yes. Next.
Number 22.
My lord, I am for the petition, my lord. My lord, wife petition, my lord. My lord, husband filed the MC petition in Bangalore, my lord. She is a resident of Mysore, my lord. She is a resident of Mysore, and my lord, along with 2 minor kids, my lord. My lord, distance.
File your objections.
No, my lordship.
You want time or you can go ahead with the matter?
I need some time
When
because
did you file your wakalat?
the child is studying.
No, when did you file your wakalat?
15th.
So and so submitted
Last
his
date
file
I
wakalat and he will
yes.
come up with his objection. This is on 23.
Yes, ma'am.
Should have filed?
Yes. Last wakalat.
You have filed or not?
15/3/2025.
That's what I'm saying.
Yes, ma'am.
23.
Yes. 25. 15/3/2025 I have filed.
And on 23 you have requested time.
My one submission, my lordship. The child is studying in Hassan. She's
File your objections. You can't make that kind of submission. This is matter finally on 16th. No further time will be
Yes,
granted for filing objections. Yes.
Number 23.
Great.
23.
Miscellaneous second appeal is by the plaintiff before the trial court.
Huh?
Miscellaneous second appeal is by the plaintiff before the trial court. I filed suit for specific performance. Agreement is of the year 2008. My lord, the
Agreement of the year?
2008.
8. Suit is of year?
2012.
Oh.
My lord, the pursuant to service of summons, my lord, defendant appeared before the trial court. They seeks, my lord, time to file the return statement. Thereafter, my lord, they have not turned out. Consequently, my lord, the suit decreed ex parte. What happened, my lord? Immediately, my lord, suit decreed, my lord, on 18/7/2013, and I filed the execution petition, my lord, on 30th/8/2013. 30th/8/2013. Summons has been served in the execution proceedings also. The counsel who is appeared before the trial court, very same counsel has been representing judgment debtor in the execution proceedings also. They are contested. The decree has not been called in question before any court.
They have not filed any application.
They have not filed any application also during their lifetime. And the judgment debtor, my lord, he died in the year 2019. And LRs were brought on record. The present respondents, my lord.
No, you have filed the execution petition on 38,
yes,
2013.
Yes.
That was not decided till 2020.
No, that is not decided. And 2019, my lord, the original judgment debtor died. LRs were brought on record. After brought on record, my lord.
LRs were brought on record in the EP proceedings.
In the execution proceedings. 2022, my lord, they filed an appeal before the first appellate court, challenging the judgment and decree passed by the trial court.
And the first appellate court, my lord, during the lifetime of the original defendant's judgment.
Let's see the order.
Please. Only 2 page, my lord, ink page number 25 and 26.
Which court is this?
First appellate court.
Chamraj Nagar.
Chamraj Nagar. Points number 1 to 3. Since the points are interconnected to each other, they are taken up together for common discussion. There is my lord, there is a delay of 11 years in filing the appeal before the first appellate court by the LRs of the judgment. Original defendant. Yes, sir. The same has been condoned. And my lord, the appeal has been allowed and remanded before the trial court for fresh consideration. My lord, para 13 onwards, when we go through the order sheet of the trial court on 12/12/2012, ex parte injunction has been granted in favor of the plaintiff respondent in the present case. Summons was ordered to issue to defendants. However, on 23/1/2013, one advocate SSP undertakes to file wakalat for the defendant. At this stage, it is pertinent to note that trial court has not issued any summons to the defendant. Subsequently, neither the defendant nor the advocate who undertakes to file the wakalat appear before the trial court. Thereafter, trial court, by placing the defendant as ex parte and pass the judgment. As could be seen from the records of the trial court, there is no memo filed by the counsel to undertake to file the wakalat. Only on the submission, oral submission, the trial court has passed the ex parte order against the defendant. When the summons were not yet issued and the counsel who undertakes to file the wakalat not appeared and did not file the wakalat and did not intimate about the defendants to the court, the trial court ought to have issued the fresh summons to the defendant, or at least the trial court ought.
Please. The present appeal is filed. I agreed with the orders passed in RA number 5070 of 2023 dated 26 November 2024, whereby the court had set aside the judgment and decree passed in voice number 327 of 2012 dated 8/7/2013 and remanded the matter to the trial court for fresh consideration. Then counsel appearing for the appellant plaintiff submits that the suit is filed in the year 2013 seeking the specific performance of an 2009.
2008. 2008 is the agreement. 12 is
Voice
the suit.
number 327 of 2012 seeking specific performance of an agreement of sale dated.
My lord, 15/5/2008.
15/5/2008. That suit came to be decreed ex parte on 18/7/2013, and on 30/8/2013, the judgment, the decree holder has filed the execution proceedings, and in the execution proceedings, the judgment debtor had contested the matter, and he died in the year 2019. In the year 2000, and then after his death, the LRs have filed an appeal, that is RA number 5070 of 2023, with a delay of 11 years. 11 years, and the court had condoned the delay and observing that you have not questioned that condonation order.
Well, both are, my lord, and
on the same day. On the same day, the delay is condoned and the appeal is remanded. It is submitted that the counsel that in the entire order there is no discussion about there is no discussion about why the original judgment debtor has not preferred any, has not assailed the judgment and decree, and how the court can interfere with an order when with the judgment and decree, when the judgment debtor, knowing well that an order is a judgment and decree, is staring at him, has kept quiet. He submits that the appellate court went wrong in remanding the matter. Next para. Having got the counsel for the petitioner, peruse the order in RA number 5070 of 2023. The court had not discussed anything with regard to where is that when that order has culminated into this order, where is that condonation delay order? Where is it?
There is no, my lord, separate.
There should be. There will be an order.
There is no order, my lord. The entire order sheet maintained by the first appellate court.
Unless and until delay is condoned, Court can't remand the matter.
ಹೌದು. First, the delay has to be condoned.
It is not condoned.
ಇಲ್ಲ, condone magiಲ್ಲ.
He
This is
submitted
the
that
entire
to
order sheet
the
I have
court
produced.
without, just so you're saying that the order is a.
ಇಲ್ಲ, common, my lord, under the, my lord, the judgment and decree, there is no such findings has
It
been
is submitted
recorded.
that without condoning the
Yes.
delay, the court had remanded the matter in his submissions. This court perused the order. Order do not refer to any of the refer to the fact how the judgment debtor kept quiet and how the court had entertained the appeal. Instead of that, court had gone into the merits of the matter with regard to the notice and other things. In that view of the matter, there shall be stay of all further proceedings in so and so, so and so. Till the next date of hearing, and counsel for the appellant is permitted to take out notice on the counsel appearing for the respondents before the trial court and shall file a memo to that effect by 2nd of June. If the memo is filed by 4th of June, if the memo is filed, list this matter on 9th, or else the stay granted by this court stands vacated. Yes. Now, remaining matters.
My lords, if I may submit, my lords, list number 2, serial number 18. My lords, I believe that my learned friend has made a misleading submission before this honorable court that the petition is disposed of. But the very same counsel has appeared in the MFA, which came to be allowed, and thereafter an order of stay was passed by your lordships in this matter.
That matter is remanded or disposed in the year
Please, my lords,
2020.
they could have said, what led me to appear through VC.
That is pending if it is remanded.
After remanding that matter, pending that.
No, they want a pending matter to be remanded. It is pending or
Please.
not?
Yes.
It's pending, my lords.
Call it in the afternoon.
My
Then,
lords, if I may request on Monday or Tuesday, I'm not in town, I'm appearing from elsewhere, my lords.
that
My
matter on
lords.
Wednesday.
Great, my lords. Interim order may be extended, my lords.
Look at it, if interim order is there, then extend.
Please, great, my lords. Great. God bless you.
1 minute. Now, in this list number 3, just look at it and don't give like other form. Give the dates, not even 2 matters on one day. So 37, 38, 39, 40, 41, 42, 43. All these matters in the month of July, some in July, some in August. Give the dates, and even 14 also. 14 also give a date. 17 matter. Yes, 17 matter. Yes.
List number 2, serial number 8, my lord. I am sorry, my lord, I came little bit late.
What happened?
In this case, my lord, notice was issued, but it was not served on the ground that no such person. In fact, the same address I have furnished.
That
No, it is not served, my lord. No such person return. I may be permitted to take the hand summons to the trial court counsel.
Yes. Hand summons in that.
And interim order may kindly be extended.
Look at it. If it is there, extend.
Much.
Huh?
List number 2, serial number 14, my lords. So an IA is filed in that matter, my lords. The IA has to be considered, my lords. I have filed an application for additional evidence, my lords. That has to be considered, my lords, in that because the matter is before the CPC branch, my lords. We have already led evidence, my lord. Cross-examination has happened, my lord.
You were not there.
Please.
You were not there. What to do?
Kindly have it tomorrow or day after tomorrow, my lord. We'll submit.
When is it posted? Yes, let it come on the. Yes.
Lord, the matter is coming before the CPC on 24th, my lord. Before that, the application has to be allowed, my lord. Next week, any date, my lord, we'll.
It's difficult for the court, every matter to again go back to the list and
Apologies.
pass orders. Difficult for them also.
Apologies.
This is matter on 17th.
Obliged.
There is a list at 2:30. Another list is there. After that list, we'll continue. That ask them, let them let it be notified to the advocates. Otherwise, they are thinking that if 2:30 list is there, this list will not be continued. So after those 2 lists, these matters will be taken. That we will, sir. Madam, instructions.
Sir, list number
List number 5.
List number 3 ನಲ್ಲಿ serial number 37 to 43 ಅಡ್ಜನ್ ಆಗುತ್ತೆ. Serial number 37 to 43 and serial number 14. List number 3, serial number 14 and 37 to 43 all matters will be adjourned. 2:30 ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ನಿಮ್ಮ ಮ್ಯಾಟರ್ ತಗೋತಾರೆ. Yes sir. That is the instructions now it is given.
List number 5.
ಇದು ಮಾಡೋದು ಸರಿ.
for appellant.
This also Wednesday.
Serial number 4, SV Prakash. SV Prakash for appellant.
Listed on 21st.
Serial number 5.
It's a case of?
Injury as well as vehicle damage, my lord. First one is allowed and second one is dismissed, vehicle insurance.
Where are the insurance councils?
A. Ravishankar, B.S. Umesh.
No representation.
No, I appear for, yes, madam. But the liability is on the other company, my lord. He has to answer.
Who is he?
Umesh.
Ravishankar, A. Ravishankar.
No representation for the respondent number 3 insurance company. This is matter on 23rd. Yes.
Number 6. Serial number 6. Shiva Reddy TN.
For enhancement. Let's. Yes.
Ankle fracture and
How much
date
is
of
the amount?
accident.
How much is the amount granted?
Total compensation awarded is 1 lakh.
60.
Mubandra. He's come.
Yes, what is the compensation?
My lord, 1 lakh has been awarded in
Contributory negligence is there?
No, my lord. No, my lord. That is
Then,
not the issue. The thing is that
It says
they were
65,000.
no, my lord. Could see the
My lord,
impugned order.
3,
Internal
4,
page
2,
10. 10.
Arising out of 6484, my lord. Arising out of MEC 6484.
6484 impugned or judgment internal page 10, internal page 10, my lord. It starts over there. There were 2 connected cases. Pilon Raider and the petitioners were traveling in the same motorbike. Because of the faulty of the opposite party's car, they claims that the tires were busted and they hit the vehicles of the petitioner's hearing. Paragraph
Total
number
amount
15.
granted is 1.
Only 1 lakh, my lord. 1 lakh has been.
Yours is MBC number 34?
3420 of 2011. 3420 of 2011.
1 lakh is granted.
Yes, my lord. In the connected matter, the Pilon Raider they moved a separate petitions, that is MFA number 6485 of 14, where that has been disposed of on 19/3/2015, where enhancement of the compensation award has been done. That was connected to MBC number 3421 of 2011.
No. Where is the other MFA is already
Disposed of, my lord.
That's basing on the facts of the.
No.
that case.
Since this judgment is connected with the both MBC joint common
No,
judgment.
liability is not the issue.
Liability is not the issue.
Only enhancement.
Enhancement. my lord.
So whatever is the disposal of that case will not have any binding on this.
No. Since with the same incident, just I want to apprise to
No,
this
that I
honorable court.
understand. If it is a case of liability, then we can understand. Enhancement is basing on the facts of this case.
Yes, ma'am.
So please come to that. How many are the injuries?
Injuries could be found at page number
Fracture of
12,
ankle.
internal page 12. Internal page 12 of the impugned order.
Hmm.
On going through, may I read it? my lord?
Abrasion to the left elbow,
Yes, ma'am.
left knee joint,
Abrasion
left
to the
foot,
left elbow,
left ankle
knee.
joint.
Yes, my lord. Left foot and left ankle joint.
No grievous injury.
No grievous injury in the sense disability percentage is, my lord.
Injury number
That's
5 is
different.
grievous in nature.
Yes, my lord. And in the wound certificate, that is at exhibit P3. That is crucial, my lord, because as on the date of the alleged, whatever the incident, accident, the petitioner's age was 23. He has done his diploma and he was diploma in electricals and electronics. He was visiting the sites for his whatever the daily living, and he was earning happily as per the 750 rupees per day, even as taking into consideration of that one. And the trial court that is the tribunal, has not even compensated for any pain and sufferings. And that is one thing. And second thing is that
It has granted
no,
30,000.
discomforts I have not given.
What is that head
Because,
discomfort?
because
Loss of
unhappiness,
amenities, you mean to say?
amenities that has
No,
not been
then
awarded.
where is the evidence of the doctor with regard to the disability?
My lord, that is at exhibit P3, the wound certificate, my lord, just for a
Wound
moment.
certificate, when you
Percentage.
say disability,
Yes,
you have to examine the doctor. Without examining the doctor, you cannot say
No,
there
no,
is.
doctor as examined, that is at
And what is, according to him, what is the disability?
PW3,
What he says?
Shiva Yogappa. I may be permitted to read, my lord. PW3, Dr. Shiva Yogappa.
P.
Shiva Yogappa.
Whether there is any disability or not, Mr.
Mobility
Raju?
component 90%.
Huh?
90%. That is permanent physical disability of lower limb. As per the claimant of
20% to the limb. 20%. Just. My lord,
25%, my lord. Total loss of movement is 25%. Total loss for knee is 6%. He has assessed as total
So
loss
to the
of
whole
movement.
body, it is 6%.
Hip, knee and ankle. Hip, knee and ankle, 6%. A. And in the last A and B, larger value 9%. That is 9 plus 6%
We
divided by,
cannot,
yes,
do
my
the-
lord, 14.5.
We cannot do that calculation. In the evidence, he must have deposed.
Yes, yes.
That we will consider. What he said, 20% to the whole body, limb, and 6% to the whole body. That's what he said.
lower limb C and D, 20%.
C and D.
Then
It comes to about 7%.
Huh?
It will work out the whole body 7%.
We'll take that. Which year is the accident?
2011, 20 to 2011.
20 to 2011.
6,500. According to him, how much is earning?
But he said 750 per day.
750 rupees per day.
How much it would be per month?
It will be around
21,000.
21,000.
21,000.
There's no proof, my lord. So Lok Adalat chart is 6,000 rupees.
This is
22,500.
2011, no,
22,500.
11, my lord.
2011 is 6,500. 500.
6,000, my lord.
No, 10 is 5,500. 11 is 6,500.
5,500 to 6,500. Suddenly, Adalat chart.
Right. It says 2010 and 11. It says 5,500 to 6,500.
No, how we are looking at is 2010, 5,500.
I got it.
11, 6,500. 6,500 into 12. What is a multiplier?
My lord, he was aged
23.
25 years.
In our petition, we claim 20.
Multiplier is? What did the multiplier is 18 or 17?
25.
21 to 25, 18 and
26 to 30, 17. 21 to 25, 18.
18. He admitted in the hospital for 10 days, my lord.
It comes to 98,280. Loss of future earning. Then loss of earning during the laid up period. $6,500 into 3.
Three months, my lord.
Yes. Then loss of amenities. 20,000.
25,000 is granted.
Already granted. Where is it?
But then conveyance attendant charges 20,000 is granted.
No, that we will reduce.
Pardon me?
Loss of amenities is 25,000.
Yes, my lord.
Then conveyance incidental charges is on the higher side. No,
20,000.
nothing to enhance.
Medical expenses only 5,000 has been.
Medical expenses 5,000.
When pain and suffering is only
On
20,000.
this disability, we will not, because we are granting.
Because yes,
loss
we have
of
granted
future-
that 20,000 should be deducted.
It comes to 2,18,280. Agreed with her. Report passed in MBC number 3420 of 2011 dated 8 July 2014. Claimant is before this court seeking enhancement of the compensation. When counsel appearing for the claimant submits that the court had not granted a just and reasonable compensation. It is submitted that the court had failed to consider the future prospects, and no amount is with the future loss of income, and also the income during the later period, and even under the head of pain and suffering, the amount that is granted is not reasonable. Next part, when counsel appearing for the respondent insurance company submits that the court had reasonably granted the compensation, there are no reasons to interfere with the same. Next part, having heard the counsel's on the side, produce some material on record. The court had granted the compensation as per the table given below. That is, at first page it is there, that you extract. This court had, considering the grievous injury sustained by the claimant under the head of pain and suffering, this court is granting 40,000. Coming to the future loss of income, as per the evidence of the doctor, he has sustained disability of 20% to the limb and to the whole body. It said 6.
We have taken 7 now.
No, the doctor.
The doctor didn't say anything. He just said 20.
Says that the whole body disability is 20%. This court has perused the order, but the court had not considered the whole body disability. And this court is taking the disability at 7% and 7%. And as there is no evidence on record to show what is the income, as this is an accident of 2011, this court is taking 6,500 as income. 6,500 into 12 into 18 multiplier into 7 by 100 is 98,280. Coming to the loss of earning during the later period, 6,500 into 3, 19,500. The court had granted reasonable amounts for loss of abilities, conveyance, and incidental expenses, medical expenses. And there are no reasons to interfere with the same. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2,18,280. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1 lakh to 2,18,280. The amount shall carry 6% interest enhanced amount. Yes.
Just a clarification, my lord. That whole body they have mentioned is 20%.
But
As the Saldo court pointed out. 20% overall body.
What is that?
Overall body, that is 20% they have.
Where do you get that?
The doctor's affidavit evidence.
What he would tell is
It's
first
the
the
Shiva
limb
Yoga
disability. Limb disability.
No, no, it's very
Third of it would be the whole body disability. Yes, next.
Much.
7. N. Krishnaswamy for appellant.
What will happen to the appeals? If Ms. Krishnaswamy is in.
He's in the Lok Adalat here.
What will happen to these appeals? The list is matter on 16th. Yes, next day.
Cell number 8. Pradeep B for appellant.
Yeah, for respondent number 1, it's matter.
Yes, Pradeep. So you are on what ground?
Filed an appeal
The driver
challenging
of
the
the-
liability.
The driver was not in.
Driver did not
Hey,
possess.
huh?
Driver
did not possess the valid and effective driving license as on the date of accident, my lord. We have filed an application before the tribunal.
No, pay and recover will apply if there is
My
no,
lord, now he has produced the driving license.
they are produced.
Owner appear here.
I'm appearing for the respondent of owner of the vehicle. But I filed an application on 41 Route 27. In my application, my lord, I will furnish the entire document relating to the, my lord, driver of the vehicle who has valid and effective driving license.
That,
as the
documents, my lord. But
my lord, for
my
the
lordship
moment, my
may
lord,
hold
kindly
that, my
see
lord.
the application filed by the appellant, my lord.
Let me listen to what he is saying. What are you saying?
Lord, before tribunal, my lord, the tribunal has given a finding.
No,
right?
no. What is your submission with regard to that?
Regarding that only, my lord, I am submitting. Before the tribunal, the tribunal holds that, my lord, the police have not filed a charge sheet under section 3 sub plus 1 stating that the driver did not possess driving license as on the date of accident. The tribunal has given that finding, my lord. My lordship may hold that the same finding, my lord, my appeal may be dismissed.
Then what about their appeal?
Their appeal, my lord, they are searching enhancement of compensation, cross objection.
Cross objection. Yes.
Loss of income.
Where is the table?
Page number.
Internal page 18.
What are the injuries?
Injuries, my lord, as mentioned. Internal page 9, my lord, 1, 2, 3, 3 injuries are there, my lord.
Injuries
Significant
are?
injury to left eye, bilateral superior pubic rami fracture and left inferior pubic rami fracture.
How many fractures?
2 fractures, my lord. Hip 2 fracture. 40,000 has been given.
Medical.
Per limb disability is 31%, my lord.
Please wait, we are going step by step. Medical expenses, how much? As per the bills?
As per the bills.
Which medical expenses is given 45,000, my lord. I have produced
Who did-
107 bills, my lord.
Huh?
It's not considered, the total of the bills is not tabulated, my lord.
So, no. Please come to the finding.
Please, my lord. Page number, internal page 12, my lord. Third line, fourth line, my lord. She has produced medical bills at exhibit P6 to P111 and prescriptions. Much of the medical records produced by her are from Hosmat Hospital. Except suggestions, nothing has been elicited to disbelieve the said bills produced by her, and even the medical bills produced by her bears the endorsement of payment seal. Though she has produced many number of medical bills, that is about 107 medical bills, she has not produced any inpatient bill of the Hosmat Hospital. She claims that prior to the 107 bills are produced, my lords, as an inpatient.
So 30 days,
Please.
inpatient for 18 days.
18 days.
Quoted granted.
45,000, my lords.
Will grant under that head 48,000. Then
My lords, loss of income taken as 4,000, my lords. Accident of the year 2008. 4,500 is the
Salman.
page number.
According to the claimant, how much is earning?
5,000, my lords.
You're earning?
5,000. She's working in a Bishop Servant College.
5,000 is earning. Which year is the accident?
2008, my lords.
Same 5,000 only.
4,500.
4,500.
4,500.
4,000 is
4,500 into 3. Then loss of future income?
Loss of future income is taken 40,800. Disability is only considered 5%.
According to the doctor?
According to doctor, total 15%.
31%
Whole body
to the-
15%.
31%
to the
Lower limb.
lower limb. 15% of the whole body. My lordship would consider 10%.
Would the trial court have taken?
5%.
17 multiplied.
5,000,
7 years. 28 years.
4,500, 12 into, multiplier is 18.
17 million.
28 years.
18 into 10 by 100.
$91,800.
How much?
91,800.
800. Hmm.
Loss of amenities is taken 40,000.
How much is granted loss of amenities?
40,000. 2008, said 40,000 is maximum.
You want more?
If my lords permit.
That is already on the higher side. It should have been. Your appeal is also there. We'll grant 20,000. 40 is on the higher side. We'll say 25,000.
30,000. No, let it be the
25.
40,000 itself. Because
He's-
my lord, she has
He's
sustained,
very generous.
Yes, my lord, she has sustained degloving injury. After the accident, she has lost her job, my lord. Degloving injury is also there. That's why. My lord.
So loss of no future operation.
There are my lords, but no bills produced as to that.
Yes, what do you say on the future operation?
No, my lord, that nothing has been stated by the doctor with regard to the future medical. No, nothing has been stated. Nothing has been stated. With regarding to future medical expense, doctor doesn't say anything. Not stated anything.
Only degloving, my lords. After that, she has undergone 2-3 surgeries. No bills produced.
We'll say 20,000 for any looking at the injuries.
Please.
Hmm. It comes to 2,83,300. Please come. Agreed with the award passed in MVC number 406 of 2009. The insurance company is before this court, and the claimants have filed MFA crop 106 of 2017. The claim petition is filed seeking compensation of an amount of rupees 12,000 for the injuries sustained by the claimant in the road traffic accident that took place on 4/3/2008. The case of the claimant is that on 4/3/2008 at about 9 a.m., when the claimant was proceeding on a Honda Activa, the driver of the tractor came from behind in a negligent manner and dashed the petitioner's vehicle. Due to the result of the same, the claimant fell down and tractor ran over her thigh. Thereby, she sustained grievous injuries. According to the doctor, she had sustained 2 previous injuries, and there is a disability of 31% to the limb and 15% to the whole body. The tribunal had considered the disability at 5% and the income at 4,000.
5,000 was taken before the trial court.
4,000 and granted the compensation as per the table given below at para number 13. When it comes to the liability, it is the case of the insurance company that the driver is not having a valid driving license. As there are violation of terms of the policy conditions, the insurance company is not liable to pay the compensation. The tribunal has held that the insurance company has failed to produce the convincing document to show that driver was not having a DL as on the date of the accident. The claimant has produced the charge sheet exhibit P2. The driver has not been charge sheeted for driving without a license, and admittedly the policy is in force as on the date of accident. And the court has held that without sufficient material, it cannot be presumed that the driver was not having a valid driving license, and accordingly held that the insurance company is liable to pay the compensation. Next para. Then counsel appearing for the insurance company submits that when there is no driving license, the court ought not to have passed on the liability on the insurance company on the insurance company and ought to have directed the owner of the vehicle to pay the compensation. When it comes to the compensation, he submits that the compensation that was awarded by the tribunal is on the higher side. Next, then counsel appearing for the owner of the vehicle submits that the court had rightly considered the evidence and rightly held that the insurance company is liable to pay the compensation. Next one. When counsel appearing for the claimant submits that the court had taken the income at 4,000, which is on the lower side, and further the court had granted a lump sum amount towards the loss of future income due to permanent disability, and even under the head of pain and suffering also, the compensation that is granted is not a just and reasonable compensation. Next part, having heard the counsels on either side, peruse the material on record. Peruse the material on record. First, coming to the aspect of liability, the tribunal had rightly held that without there being any evidence on record, and particularly in the light of the fact that the charge sheet is filed. In the charge sheet, it is not the case is not registered against the driver that is not having a driving license, and no other material is placed before the court. The court had rightly held that the insurance company is liable to pay the compensation, and this court finds no reasons to interfere. Next part. Then coming to the aspect of compensation, considering the two previous injuries that are sustained by the claimant, this court is granting an amount of ₹60,000 under the head of pain and suffering. Medical expenses, transport, and other miscellaneous expenses, court had granted 45,000, and this court is granting 48,000. Then coming to the loss of income during the later period, this accident had taken place in the year 2008, and this court is taking as per the chart 4,500 into 3, 13,500. Then coming to the loss of future income, 4,500 into 12 into 12. And coming to the future loss of future income, the doctor had opined that the disability is 15%. The disability is 15%. When the whole body disability is 31%, the disability to the limb is 31%. Court cannot take the court as stated by the doctor. It cannot be 15%, and this court is taking the disability at 10%. 4,500 into 12 into 7 into 10 by 100 is 51,000.
17.
17. 4,500 into 12 into 17 into 10 by 100 is 91,800. Loss of amenities, court had granted a reasonable amount and no interference is called for. Considering the injuries to future medical expenses, not operation, we'll say future medical expenses. This court is granting an amount of ₹20,000. In the light of the law laid down in so and so, 10,000. Altogether, the claimant is entitled for an amount of ₹2,83,300. Accordingly, the appeal of the claimant is partly allowed. Enhanced the compensation from so and so to so and so. Enhanced amount shall carry 6%, and the insurance company is liable to pay the compensation.
Total compensation amounts.
Amount in deposit shall be forthwith transferred to the
Claimants are not entitled to interest for a delay of 1,191 days.
How many days?
1,191.
As per the order dated so and so, the claimants are not entitled. Claimants are not entitled for interest for so and so period. Verify the order sheet.
My lord, IA may be disposed of.
Because we have given a finding. So let's not.
That has
the
to be
IA
remitted back to tribunal.
that's why
If
you're not
the original document
understanding.
has to be considered.
IA number so and so filed by so and so is dismissed as and because that aspect need not be gone into the court. As this court is not going into that aspect at all.
Yes.
Much of it. Appeal of this is dismissed. Yes,
Amount in deposit limit. Amount in deposit.
Amount.
Yes.
Cell number 9, Pradeep B for appellant.
Yes, ma'am. It's a case of injury.
Second one.
Respondent. Involvement of the vehicle is present, my lord. the manner of the accident,
Involvement of the vehicle is questioned.
the manner of the accident, my lord, narrated by the first respondent injured is different one, my lord. In the course of cross-examination, he admits that while he was riding the motorcycle, at that point of time, driver of the auto rickshaw drove the same in a rash and negligent manner and dashed against the motorcycle from behind. As per the complaint and
We'll see the facts of the case.
please. Fact of the case is, my lord, on the accident occurred on 3/3/2013 at about 11:30 a.m. while the first respondent going on the left side of NH4 service road in front of Nurla Garden. At that point of time, driver of the auto rickshaw wearing number so and so drove the vehicle in rash and negligent manner and dashed against him, my lord. That is the complaint and his version also. That is in the course of cross-examination, he has stated that while he was riding a motorcycle, the auto rickshaw came and dashed against him. Motorcycle.
He said he was going on the left side of the road. Where did he say he is walking?
He is walking.
Oh, he's just walking.
Complaint.
It's not say or walking or on bike. Only say going. In complaint on the FIR
Going by
also.
bike only, he has stated in the cross-examination.
No. So he is going in the complaint. He is going by bike in the cross examination. Doesn't make any difference. He
Auto
didn't
rickshaw-
say.
auto rickshaw is
no,
same, but
he
never
didn't say
say-
while I was walking on the left side of the road. Then if he says on the bike, you can say that there is a contradiction. That's the only thing.
That is the only thing, my lord.
Please come.
Afterwards, my lord, further, my lord, the loss of amenities, my lord, where there is no doctor evidence.
Let's see that.
60,000 has been granted, my lord.
Let's see that.
Please. my lord.
Table has not drawn.
Para-
Only
para
at para
14.
number 14 it is stated.
No. Let's see. You in your synopsis it must be there.
Yes, my lord.
Pain and suffering
45,000. On
Basing
fracture
on
of-
what loss of amenities is granted?
No doctor evidence, my lord. 60,000 has awarded.
Fracture of clavicle, my lord. Doctor has stated
Not
total
examined.
30% to disability certificate produced here. with me,
Not
no?
examine the doctor.
Not examined. But anyhow, some loss of amenities will be considered. my lord.
And loss of income during the period 30,000 has
So
awarded.
that we will do. In that we will do.
Please, my lord.
No, then we'll adjust the amount like that. So,
Parent suffering 45,000.
no, 1 minute. How
Please.
many are the fractures?
Only one fracture.
Hmm,
Fracture of left calcaneum.
45,000. Then loss of income during data period. Which year is this?
2013, my lord.
Amount is?
30,000 awarded, my lord. 8,000 of the.
Oh,
lost
it's
my lord.
already awarded.
Awarded.
Uh,
That would be 24,000, my lord. 8,000.
Treatment expenses, 2,000. Then how many days you were in? He was in hospital.
Was, 15 days he was stated.
So in that we'll grant nourishment.
713 is income
1
7,000.
minute. Attendant. 15 days. 15,000 will take.
Please.
Hmm. No, how much was 2013 income?
8,000.
Even that is also real. 30,000 is granted.
For
Generally,
laid-on
3
period.
months the court is granting.
Yes,
Three
ma'am.
months,
It comes to 24,000.
24,000.
Court granted 30,000. So where will this, for the 60,000, this nourishment and attendant 15,000 is granted by this court. So the difference is another 45,000. That has to be reduced.
And the loss of amenities, there's 60,000 maybe.
Loss
give
of
it in time,
amenities means there should be something on record to grant.
The wound certificate is there and also
Then we'll
disability is there,
say,
but doctor has not examined it.
Loss of amenities will grant 15,000.
15,000.
Hmm. It comes to 1,07,000 from 1,37,000. 30,000 difference.
Interest 9% as awarded.
Is awarded.
Maybe Captain,
6%.
interest let it to 9%.
Interest in every case it is
And is
6%,
deducting.
not only in your case. Agreed with
because,
orders passed in MSC number 5 and 3 of 2013 dated 17 January 2015. the insurance companies before this court, questioning the involvement of the vehicle as well as the compensation that is awarded. It is the case of the claimant that on 3/3/2013 at about 11 a.m., he was going on the left side of the NH4 service road in front of Nurullah Garden at that point of time. The driver of the auto rickshaw came in a rash and negligent manner in a high speed and dashed against him. Next part. It is a case of the insurance company that in the cross-examination he said he was going on the motorbike on the left side of the road, whereas in the claim petition it is said he was going on the left side of the road. There are contradictions in the case of the claimant, which shows that he has not come to the court with the true facts and with clean hands. And in spite of the same, the tribunal had granted compensation. Then counsel further submits that under the head of loss of amenities, the court, without there being any evidence with regard to the disability and without examining the doctor, had granted an amount of ₹60,000, which is on the higher side. As such, the same needs to be appeared by this court. Next paragraph. Then counsel appearing for the respondent claimant submits that the court, looking at the evidence on record, had rightly granted the compensation, and it is never the case of the claimant that he is walking on the road, and there is no discrepancy either in the case in the claim petition or in the evidence adduced by the claimant. As such, no interference is called for with the well-considered order passed by the court. Next paragraph. Having got so and so. The first, with regard coming to the submission of the counsel appearing for the insurance company, that in the petition it is stated that he is going on the left side, and in the evidence it is stated that he is going on the bike on the left side of the road, and according to as per his submission, according to the insurance company, the claimant has put forth two different versions. The said submission, this court is not able to agree and appreciate, and it is nowhere that he said that he is walking, and it can't be. And the submission of the insurance company has no legs to stand, and the tribunal had rightly held that the accident had taken place because of the negligence on the part of the driver of the offending vehicle, and the insurance company is liable to pay the compensation. Then coming to in the contentions, you wrote about the interest part. Interest part also, it is 9%. This court had perused the order of the tribunal. The claimant has not examined the doctor. Without there being any evidence, court had granted an amount of ₹60,000 towards loss of amenities. As rightly pointed out by the learned counsel for the claimant, that's on the higher side. At the same time, the court is not granted the loss of income during the laid-up period. Further, laid-up period. Coming to the amenities, no doubt the claimant had sustained the injuries, and there is a disability certificate, but no doctor was examined. Considering the facts and circumstances of the case, for the loss of amenities, this court is granting an amount of ₹15,000 instead of 60,000. Coming to the loss of income during the laid-up period, as this is an accident of already granted
20,000.
For the attendant and the nourishment and transport, no amount is granted. Considering the fact that he is there in the hospital for 15 days, this court is granting 15,000. Altogether, the claimant is entitled for an amount of ₹1,07,000. Accordingly, the appeal of coming to the interest part, the interest amount is reduced from 9% to 6%. Accordingly, the appeal of the insurance company is partly allowed, reducing the compensation from so and so, and also the rate of interest from so and so to so and so. And the amount in deposit shall be forthwith transferred. Next.
Bill number 10, Kalyan R for appellant, B. Lakshmi Rao for respondent.
There is one appeal filed by me, another appeal is filed.
Who appears?
Kalyan R.
Your Kalyanar.
No, I am Lakshmi Rao. I am appearing for KSRTC.
You are appearing for the KSRTC. You're on what ground?
I'm on the ground of both negligence and quantum.
No representation for the counsel appearing for the claimant. Counsel for the KSRTC is present. This matter as part heard on 16th April.
Channel number 11.
My request was 17th.
Patient Latur, for appellant.
For the appellant, my lord.
Yes.
Sorry.
The claim petition is dismissed, my lord.
Was dismissed.
Yes. On what ground?
On the ground that, my lord, the claimant was a driver of a one vehicle Scorpio car. The accident has taken place in between the Scorpio and the Maruti car, Maruti Alto car. In this case, the Maruti Alto car driver has filed a complaint before the police. The police have charged it against the
We will read issue number 1.
Scorpio car, my lord. Page number 6, my lord.
Yes, please read.
May I read it, my lord?
Yes. Read from
On
issue number 1.
On careful perusal of the records, it reveals that this petition is filed under section 166 of ME Act against respondent number 1 to 5. Respondent number 1 to 3 are the owners and insurers of the Scorpio vehicle bearing number K18M7018, and respondent number 4 and 5 are the owner and insurer of the Alto car bearing number K04MH711. Further, the records reveal that the petitioner filed a memo on 21/8/2014 requesting this court to delete a respondent number 1 to 3 as a party to the petition, for which respondent number 3, who is the insurer of the Scorpio car, submitted no objection. In view of the memo and submissions by the counsel for a third respondent, the petition against the respondent number 1 to 3 are deleted from the petition. Hence, there remains respondent number 4 and 5, the owner and insurer of the Alto car. Issue number 1, it is the case of the petitioner that on 1/4/2012 at about 6:15 p.m., he was driving a Scorpio car bearing number K18N7018 at Dodagere village near Nelamangala. At that time, a Maruti Alto car bearing number K04MH711, which was moving ahead of his vehicle at high speed, suddenly applied brake without giving any signal. As a result, he could not control the car and dashed against the Maruti Alto car and fell into the dig. The petitioner, due to which he sustained grievous injuries. Hence, the accident occurred due to the rash and negligent driving of the Alto car. In order to substantiate the cause of accident, petitioner filed his affidavit, which is nothing but a replica of a petition amendments, and he has also produced the documents marked at exhibit P1 to P5 that is FIR with complaint, charge sheet, Mahajar, IME report and discharge summary. On the other hand, fifth respondent, who is the insurer of the Alto car bearing number K04MH711, had taken up a specific defense contending that the petition is not maintainable since the accident was due to a sole negligence of the petitioner but not the driver of vehicle. The documents filed by the petitioner do endorse that it is due to his negligence. Since the accident was not due to negligence of its driver, it cannot indemnify the risk of the owner of the vehicle and requested to dismiss the petition. In order to prove its specific defense, fifth respondent examined its assistant manager as RW1, who has also reiterated the same in his affidavit. Though he was subjected to lengthy cross-examination, but nothing is elicited. In the light of these rival contentions, let us ascertain whether the accident was due to negligence of the Alto car. As could be
Sir?
seen from the
Hello, sir.
records, it reveals.
Hello, sir.
Yes, my lord.
Yes, I have seen that. Please make your submissions. I've seen the order.
My lord, here in this case, the respondents have not led any evidence, eyewitness or any police officers, even the FIR which has been filed by the Alto car driver. That car driver was also not examined before the court, my lord, to prove that that is an FIR. FIR has not been proved by them. And even the charge sheet witness has also not been examined, my lord, to prove that the charge sheet. Therefore, the police records on which the Honorable Tribunal has relied upon cannot be relied upon on the police records. So there is a evidence led before the tribunal is the only evidence of a petitioner who is a eyewitness to the accident, and there is no other evidence before the tribunal, my lord. That the tribunal has to decide the case only on the basis of the evidence led before the tribunal. It is a decision of our own High Court as well as the Supreme Court also, my lord. To determine or to decide the negligence, my lord, there must be some evidence on record before the tribunal. Here, my lord, there is no evidence against the petitioner to show that there is a negligence on the part of the petitioner, my lord.
Yes.
Under such circumstance, my lord, here there is an evidence of a petitioner that he has given the evidence, detailed evidence, and as per that evidence, my lord, the negligence is of the Alto car, my lord. He has applied the sudden brake and the accident has taken place, my lord.
Yes.
Therefore, my humble submission, I am the law laid down by the Honorable Supreme Court. I am relying before this Honorable Court, my lord. I have produced the decisions also. 2014 ACJ 2550. 2014 ACJ 2550, in which, my lord,
What is there?
in which
It says some judgment he has given in the file.
It's a petition under section 166. Surendra Kumar Arora case is squarely applicable, Supreme.
Yes. Para number?
My lord, para number 13 of the decision, my lord. Para number 13 of the decision with regard to the apportionment of contributory negligence at 25% on the part of the appellant father and 75% on the driver of the offending tractor as determined by the High Court. We refer to the judgment of this court in Jiju Kurvila versus Kunjugamma Mohan 2013 ACJ 2141 Supreme Court, as it is applicable to facts of the case on hand. In the above case, Joy Kurvila had a head-on collision with a bus approaching from the opposite side. Joy Kurvila sustained serious injuries and died on the way to hospital. The tribunal found that the accident occurred due to the rash and negligent driving of the bus driver. It apportioned the contributory negligence between the driver and the deceased in the ratio of 75-25 on the basis of pleadings and evidence on record. In the above said case, this court has held thus on the negligence of the driver of the bus. The mere possession of the vehicles after accident, as shown in the scene Mahajar, cannot give a substantial proof as to rash and negligent driving on the part of one or the other. When two vehicles coming from opposite directions collide, the position of the vehicles and their direction, etc., depends on a number of factors like the speed of vehicles, intensity of collision, reason for collision, place at which one vehicle hit the other, etc. From the scene of the accident, one may suggest or presume the manner in which the accident occurred. But in absence of any direct or corroborative evidence, no conclusion can be drawn as to whether there was negligence on the part of the driver. In absence of such a direct or corroborative evidence, court cannot give any specific finding about negligence on the part of any individual. Para 25, postmortem report, exhibit P25, exhibit A5 shows the condition of the deceased at the time of death. The said report reflects that the deceased had already taken a meal and his stomach was half full and contained rice,
I'll record those judgments.
vegetables and meat
Hello, sir.
pieces in
Hello, sir.
fluid with.
Hello.
Yes, my lord.
I'll record all those judgments. Agreed with orders passed in embassy number 3979 of 2012, dated 24th February 2015. Agreed with the dismissal of embassy number 3979 of 2012, dated 24th of February 2015. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees 8 lakhs. The facts of the case were that on 1/4/2012, at about 6:15 p.m., the claimant was driving the Scorpio car. At the time, a Maruti Alto car, which was moving in front of the Scorpio at high speed in a rash and negligent manner, suddenly applied brake without giving any signal. As a result, the Scorpio dashed against the Maruti Alto and fell into the pit. Due to the impact, and the claimant had sustained various injuries, immediately was shifted to the hospital, wherein he took treatment and spent considerable amount. The tribunal had dismissed the claim petition, holding that this claim petition is filed under section 166 of the Motor Vehicles Act, and the claimant himself is driving the vehicle. Basing on the complaint given by the owner of the driver of the Maruti Alto, a crime is registered against the claimant, and the claim is registered against the claimant, and a charge sheet is also filed against him. The court had considered this aspect, and also the fact that the damages reflecting from the IMB report marked at Exhibit P4 discloses that the claimant vehicle was damaged in the front side and the Alto car was damaged on the rear side. The damages reflecting from the IMB report do endorse that the petitioner that the claimant was negligent in causing the accident. So in total, looking at any angle, the tribunal came to the conclusion that the claimant has utterly failed to prove that the driver of the Alto car was negligent in causing the accident. Further admission made by the claimant and the documents placed by him shows that he was negligent in causing the accident. Court has also extracted the evidence of the claimant, wherein it is stated that on the day he was driving the vehicle belonged to one Garish. His vehicle is behind the Maruti Alto car. It is true to suggest that he dashed against the Maruti Alto car, which was proceeding ahead of the claimant. And it is also stated that it is true to suggest that inmates of the Alto car has filed a complaint against the claimant, and the charge sheet was filed against him. The court also observes that when a charge sheet is filed and he is not at fault, he could have taken some steps to file an appropriate petition to quash the complaint, quash the charge sheet, but no steps are taken. And even apart from that, no other independent evidence is available on record, and accordingly dismiss the claim petition. Then counsel appearing for the claimant submits that the court had considered the police records, and the respondents have not examined anybody in respect of the charge sheet or any other evidence placed on record without examining the IO or any witness in support of the said police records which are filed before the court. The court cannot consider the said evidence on the face value of it. It is submitted that the claimant has proved that the accident has happened because of the negligent driving of the driver, negligence on the part of the driver of the Alto car, whereas the respondents could not prove that there was no negligence on the part of the driver of the Alto car, and still the court had granted had dismissed the petition. He had relied on the judgment of the apex court in Kiran versus Sargent Singh and others, reported in 2014 ACJ 2550, and another, and also
Our own High
another
Court decision is there, my lord. 2015 ACJ 1216.
2015 ACJ 1216, and relying on these judgments, it is submitted that basing on these grounds, the court cannot come to the conclusion that there is negligence on the part of the claimant, and the order impugned needs to be set aside. Next paragraph. When counsel appearing for the respondent insurance company submits that when the application is filed under 166, the burden lies on the claimant to prove that there was negligence, that the prima facie to prove that the accident has happened because of the rash and negligent driving of the driver of the opposite vehicle. It is submitted that in this case, no such evidence is adduced, and the court had rightly dismissed the claim petition, and there are no grounds to interfere with the same. Next paragraph. Having heard the counsels on either side, produce the material on record, the claim petition was rightly dismissed by the court, and court had rightly considered the evidence of PW2, the police records, which clearly discloses that because of the negligence on the part of the claimant, the accident has happened when the claimant himself is negligent. And if at all the claimant is not negligent, he would have taken steps to question the charge sheet which is filed against him. And it is not even the case that he is not aware of the same. In the evidence also, it has been categorically admitted by the claimant, and the contention of the learned counsel for the claimant that the insurance company has not adduced any evidence, has no legs to stand for the reason when the claim petition is filed under 166, the initial burden lies on the claimant, which he has failed to discharge. The judgments which are relied on by the learned counsel for the claimant do not apply to the facts and circumstances of the case. And in the considered opinion of this court, the tribunal had rightly dismissed the petition. And no grounds to interfere. Next.
Much.
Still. Still number 12.
One matter will complete it. Yes, 12.
12.
For appellant, there are 3 appeals, my lord. 2 by the claimant, my lord. 1 by the insurance company, my lord.
Insurance company is on what ground?
My lord, this is an accident occurred. 2 claim petitions filed before the same MST. One is dismissed, another 40,000 rupees awarded by the learned MST, same MST. That is questioned before this by the insurance company. When one case is arising on same accident.
By the very same tribunal?
Same tribunal. Davangere, MST Davangere. One is...
Is it correct? One claim petition dismissed, the other is allowed.
40,000 is awarded. That is questioned before this.
We'll hear this on Tuesday.
Please.
Parker.
Please.
Cell number 13.
I appear for the appellant, madam.
Yes.
AM Venkatesh.
Yes, Mr. Srijal.
Yes, my lord. My lord, in the connected appeal, the insurance, my lord, in both the appeals, 2 appeals were there. In both the appeals, insurance company questioned the negligence on the part of the finding on negligence on the part of the scooter. But in the connected case, insurance company admitted their liability and deposited the amount satisfied. Therefore,
what is the number?
Yes, 5631.
MFA
5631 of 16. It is kept before that order.
Take that order. Take that order.
So this appeal does not survive. Lordship may make that in view of the admission by the insurance company as a negligence aspect, I cannot argue. And regarding quantum, 61,000 is awarded. That is fair award.
To the present MFA is filed, questioning the order passed in so and so, so and so.
Yes, common judgment.
Against the order passed in MBC number so and so. MFA number 5631 of 2016 is filed in that.
Yes.
The insurance company is before this court questioning the negligence, and in the connected appeal, the insurance company, an order was passed in the Lok Adalat on 8th February 2020, and the insurance company has agreed to deposit the amount accepting the negligence in view of the orders passed in MFA number 5631 of 2016, dated 8th February 2020. Now, this appeal also
On
uh,
negligence.
on the appeal of the insurance company on negligence is dismissed. The amount in deposit shall be
And the
forfeited.
quantum awarded is also reasonable, your lordship means. Quantum awarded is also quantum of compensation, 61,000 what is awarded is also reasonable.
And this,
On all-
and as far as the quantum is concerned, this court has perused the order, and a reasonable compensation is granted. Even on that count also, no interference is called for. Yes,
Sir,
remaining all matters shall continue as it is. Next on the, and I think from that day, I think they will be coming, no. All these matters list on 22nd.
My lord, list to serial number 22, my lord. My lord, interim order kindly be extended.
When is list 2 completed? When are you making a mention?
tell us, I
That's all.
Already order is signed. Yes.
Court of sir? Court of sir?
ನೋಡಿಮ್ಮ ಅವ್ರನ್ನೆಲ್ಲ ಕಷ್ಟ.
ಹೇಳಿ ಸರ್.
List number 3, serial number 3 ಏನಾಯ್ತು? List number 3, serial number 3.
ಸರ್ ನೀವು ಕನೆಕ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಅವಾಗ ಕಾಲ್ ಆದಾಗ 9-4 ಹೋಗಿದೆ ಅದು.
Okay, thank you, madam. Thank you. 9-4. ಈಗ ಅಲ್ಲ ಈ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಒಂದೇ ಕೋಡ್ ಕನೆಕ್ಟ್ ಆಗಕ್ ಆಗೋದು, ಇನ್ನೊಂದು ಕೋಡ್ ಆಗೋದೇ ಇಲ್ಲ.
ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅದು ನಮ್ದು.
ನಾನು ಪೋರ್ಟಲ್ ನಂಬರ್ 5 ಅಲ್ಲಿ ಇದ್ದೆ,
ಅದೇ
ಇಲ್ಲಿ ರೀಚ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
Court officer? Court officer?
ನಾವೇ ಬರ್ದ
Court officer?
ಸರ್ ಹೇಳಿ.
ಅದು ಸೀರಿಯಲ್ ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 42 ಯಾವ ಡೇಟ್ಗೆ ಹೋಯ್ತು?
ಲಿಸ್ಟ್ 3
ಲಿಸ್ಟ್ 3 ಸೀರಿಯಲ್ ನಂಬರ್ 42
ಜುಲೈಗೆ ಹೋಗಿದೆ ಸರ್. ಆಲ್ 22, 23 ಮ್ಯಾಟರ್ಸ್ ಇನ್ ದಿ ಮಂತ್ ಆಫ್ ಜುಲೈ ಅಂಡ್ ಆಗಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್.
ಸ್ವಲ್ಪ ಎಮರ್ಜೆನ್ಸಿ ಇತ್ತಲ್ಲ ಮೇಡಮ್ ಅದು?
ನಾವೇನ್ ಮಾಡೋಣ, ಅದು ಅರ್ಜೆಂಟ್ ಆಯ್ತು.
ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಿದ್ದೆ ನಾನು.
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕೇನೋ ಸೈನ್ ಮಾಡಿ. ಎಲ್ಲ ರೆಫರ್ ಟು ಲೋಕಲ್ ಅದಾಲತ್ except 3 matters. All other matters, list number 6 in list number 4 and ಯಾವ್ದದು 82 and 94 ನಮ್ದು ಲಿಸ್ಟ್ 5 ಎಲ್ಲ all matters refer to ಲೋಕ ಅದಾಲತ್. ಡೇಟ್ ಏನಿದೆ ಇಲ್ಲ, ಇದು ಯಾವ್ದೋ ಫೈಲ್ ಒಂದು ನೋಡು, ಇದು ಯಾವ್ದು ಡೇಟ್ ನೀವು ಅದಾಲತ್ನ ಅಪ್ರೋಚ್ ಮಾಡಬೇಕು. ದೇ ವಿಲ್ ಅರೇಂಜ್ ದ ಡೇಟ್ಸ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ.